truth and transparency. Idaho4. Yeah, let's say good morning, everybody. We're going to be talking about the motions in limine. There's a bunch of them. Thank you for being here. Grab your favorite blanket, pen. Woo! All right. Lots to chat about. I'm still working out some of the stuff. I'm redoing this studio, so I don't know. I can't get any of these brand new 6 cameras going. 4 monitors, 6 cameras. What the heck? Yay. Welcome, moderators, subscribers, members, lurkers. We're going to jump right into it, guys. So real quick, though, these are some of the ones just getting out of the way. There was a new motion put in, and this is for the defense to file additional expert witness disclosures. That's just something that came out today. So, but we're going to get through the stipulated motions, which when they say stipulated to, that means both sides agree, and both sides have agreed for the trial purpose. They're going to allow both of their investigators. So the parties have agreed that they're not going to have their investigators sequestered, meaning that they're going to be able to be in the trial at all times. So the parties agree that the defense will have both of their investigators present during the trial, and the state will have its lead investigators, Moscow Police Department, Brett Payne, and from the Idaho State Police, Darren Gilbertson. They'll be present during the time without limiting their ability to testify. So that's pretty much what happened in the Richard Allen case. All of like Mullins, Holman, all those dudes from the Indiana State Police, they were in there the whole time. And the defense had their private investigators in there, but their private investigators didn't even take the stand. So again, good morning. Stipulated motion to file defense exhibits with the autism that was filed under seal. Defendants or stipulated motion to file that was for number 5. So motion number 5. Then they also had the autism, all of those exhibits, those are under seal for right now. And the stipulated motion to seal the parties' stipulated agreement. Other than that, everything is wide open. So we got that out of the way. We're going to go in some type of order here, which I've decided that motion and limine number 1 is what we'll start with. Look at that. This one is inflammatory evidence. What that means, guys, is obviously we know this is a gruesome crime, but Bryan C. Kohberger, by and through his attorneys on record, they just want to, they're moving for the court to prevent the prosecution from introducing irrelevant and unfairly prejudicial photographs, testimony, and other exhibits in violation of his rights to a fair trial. So they want to limit it. They just want to limit the amount. So, and this is what they're saying, because News Nation has a problem reading, so we're going to make sure that we get this. Mr. Kohberger respectfully requests that this court order the state to not try the case through eliciting testimony and other evidence that is exceptionally inflammatory. Okay. I saw it with a little bit with the Delphi case. So presenting the case in an emotional and inflammatory way is unfairly prejudicial. Do not tug at the heartstrings of the jurors. Any probative value is less than the danger. Additionally, the prosecution should not present the same information in a variety of ways, which is misleading or cumulative and a waste of time. Remember, they have this trial slated for 3 months. 3 months. I got my bell, baby. So the case contains over 68 terabits of data. I'm going to show you. Let's see. Take this puppy right here. See this big old thingy? Very thick. Yeah. Talk about having just, a bunch of those, 32 to 68 of those laying around. This data contains thousands of photographs. Many depict roughly the same content. There are photographs that depict the deceased as well as the same location without the deceased. Multiple officers took photographs of the same areas. Additionally, there are many hours of body-worn camera footage. Body-worn footage depicts the officers moving throughout the house. There are hundreds of photographs of autopsy proceedings. In addition to this evidence, over 100 officers and investigators have been involved in the case and hundreds of people that have been interviewed. Mr. Kohberger seeks to protect the integrity of his trial and requests an order preventing inflammatory evidence, including testimonial evidence, be excluded. This is where it appeals to emotion, passion, or prejudice of the jury through use of inflammatory tactics. So like I just said before, having Officer Smith, Officer Noonans, Gunderson get up there like Lally did in a way, and do so much repetitive stuff and show the same type of photos over and over and over. So Mr. Kohberger acknowledges the Idaho Supreme Court has held that a photograph cannot be excluded merely on the basis of being gruesome. However, Mr. Kohberger is not making that motion. So do not get it twisted, News Nation. Do not get it twisted, mainstream media. Okay? I believe that the defense wants the jurors to, they don't want to lose the jury before they get to present anything that they're going to present. Cumulative. Think about it. Lally drowned us in the Karen Reed case. Like, it was snowing. I sat here. I think about that now. Like, that's the type of stuff that we're talking about. Mr. Kohberger is not making that motion. Rather, he is requesting the state be prevented from introducing inflammatory evidence. And then it goes on to talk about the different studies that have been done. Multiple studies have found that mock jurors are more likely to convict when exposed to graphic photos. Goes on to talk about, though, that other studies have shown that judicial instructions to ignore such evidence are insufficient and ineffective, while some have actually found such instructions cause jurors to place more emphasis on that evidence. So it's like, we don't want you to say that either. Mr. Kohberger's right to a fair trial, free from irrelevant, cumulative, it's a big word there, and unfairly prejudicial evidence as granted by the Constitution of the state of Idaho and the United States of America, would be violated to allow exhibits depicting gruesome details or the emotional reactions of the police officers at the scene or during their testimony during the trial. So if people were truly barfing, these police officers were barfing, okay, that would be something that, like, that's not necessary. Okay. We're not, like, to play the body cam of the officer barfing. Okay. To play maybe body cams that are showing, we have no idea what this crime scene is going to look like. And there's some stuff that would be with the defense is saying over, like, we don't know. I have no idea. I can tell you that in the Richard Allen trial, They definitely limited it. It was definitely limited. So, again, these are all going to be orally argued here in a month. So that is the inflammatory evidence. Next, motion limine. Vague and undisclosed expert testimony. This was my favorite one. This was my favorite motion limine because it's going to list out pretty much what we can expect to see in this trial. And from where I'm sitting, Ashley Jennings did not listen to Hitler. So allowing vague and undisclosed expert testimony violates Bryan's federal and state constitutional rights. So it goes on to list that. I'm not going to talk about this, but I will start right here where we're talking about the people that the defense either wants to not even have, but allow them to have, or that they're limiting what they can talk about. Okay. And this is awesome. This tells me that a lot of work has gone into this. So number one here is Mr. Kohberger's request, exclusion and or limitation keyword of the following expert testimony. So number one, this forensic scientist, Ayers, her testimony must be limited to only her work depicted in the Idaho State Police Forensic Laboratory Report 25 and her checklist of testing in Mr. Kohberger's apartment and office. Here's my side note, which is right here, which is, wait, what? I thought that they didn't do any testing in the office. I have that documentation. We were all told that they didn't even bother doing anything with the office. So I'm interested in what they mean by the office. But they want, hey, this person can testify. They're going to stick to report 25 and they're going to stick to the stuff that they've done. Any other testimonies outside of Idaho Criminal Rule 16, Idaho Rules of Evidence, the court's scheduling order, which was, remember, you have to disclose what you're going to be talking about so that we can have an expert to combat it. Moving on. Next person. Oh, yeah. Number 2. Shake it on down, Cy, baby. Here we go, Cy going up against FBI Special Agent Nicholas Balance. The defense is saying, hey, his testimony must be prohibited. Must be just prohibited, as no report containing findings or opinions has been produced. Remember I told you guys this? His little way of doing it in the Vallow case, where he's just going to have his PowerPoint presentation where he clicks through and has his 100 slides, it ain't gonna fly here, okay? This is not the Lori Vallow case. This is a highly, highly contested guilt or innocence phase, right? And Nicholas Balance, according to the defense, the only disclosures are 2 PowerPoint presentations. One is noted as a draft. The PowerPoint depicts information derived from cell tower data, call detail records, drive test data, and interpretation of the same. It is abundantly clear that in creating this PowerPoint, Special Agent Balance used an unknown methodology. There it is, Hank Brennan methodology, to analyze and visualize certain data contained within the defendant's cell detail records while omitting and or ignoring other relevant data. So the argument here is that we're not saying that you're not an expert in the field. That's not what we're arguing. We are arguing that what we have been supplied is exactly what I just said. And it is abundantly clear that that PowerPoint used an unknown methodology to analyze and visualize certain data contained within the defendant's call detail records while omitting and ignoring relevant data. And that relevant data, the defense is saying, is exculpatory. Okay? So it is impossible to determine why certain data was included in the PowerPoint while other data was omitted / ignored as Special Agent Balance has produced no report documenting his actual findings. So just because you have these PowerPoint slides and presentation, if usually what comes with that is I'm going to be describing to you what each slide says. Normally what you would have is your PowerPoint presentation, then with your report attached to it. What the defense is alleging is that there is no report attached. It's just PowerPoints of probably like a bunch of maps, their little arcs, shit like that. Ready? Psy-Ray is their expert. Obviously, we know this. Usually have your experts help you when you draw up stuff like this. So I guarantee you that Psy-Ray was involved in helping the defense write up what he's seeing in it. The omitted, ignored data referenced above is exculpatory evidence in Mr. Kohberger's defense. The call detail records in full. So basically they're saying you're just using part. Provide partial alibi corroboration. As such, the complete lack of disclosure as to any opinion and or report addressing this issue from Agent Balance makes it impossible to anticipate what he may testify to as an expert on this matter. In its expert rebuttal disclosures. Now, this is what I think is going to be interesting. We've been hearing it. Like, what type of relationship does Ashley Jennings have with someone like Nick Balance, who she was seeing every single day during the phase of the investigation to find the perpetrator? Okay. I can't imagine that Ashley Jennings and Bill Thompson completely lost contact. Same with Payne. Once, okay, Bryan Kohberger's arrested, we just haven't heard from, Nick Balance in over 2 years. Okay. So just like the defense is using Psy-Ray to help build their, documents that they're turning in and their arguments because they're consulting with their experts, you would think that the state, if they're doing their due diligence, is doing the same thing. So just, it's interesting to see that the defense is accusing, like, hey, what are Balance's opinions? Where's his report? In its expert rebuttal disclosures, the state provided, which is interesting, in its expert rebuttal disclosures, a rebuttal witness is somebody that I get because of who you're going to have. Okay. It is the prosecution's case, you guys. So in its expert disclosures, these should all be here with the expert disclosures. And we're going to get into that where the defense is asking for sanctions. We're going to get into that basically the state didn't provide the material first. The defense did when you're talking about releasing your experts. So the defense is saying, hey, wait, we don't have things that we need. But here in its expert rebuttal disclosures, the state provided a summary of Special Agent Balance's proposed testimony. It's like basically it's like misplaced. Like, why is it over there? It should be right here. Portions of the summary are in direct conflict with his previous PowerPoint disclosures. So here they're accusing and saying that your rebuttal is you're rebutting your own shit. They have a rebuttal witness for their own witness, but he's the same witness. And he's in fact contradicting his expert testimony. Like, make it make sense, y'all. This is what they're saying. So again, portions of the summary are in direct conflict with his previous PowerPoint disclosures, further complicating Mr. Kohberger's guesses as to what his testimony may be. That's wild to hear that, as an accusation. Mr. Kohberger's expert, Psy-Ray, give it up, Psy. He is going to shred these mofos. Literally, daddy style, shred them. Mr. Kohberger's expert, Psy-Ray, has conducted a detailed analysis of Special Agent Balance's PowerPoint and found severely flawed findings that are well outside of established and known best practices in the field. It's like, what have you done, boy? You know better. We know you know better. So this is where I'm talking about. If you think somebody's guilty or you have like this evidence where you go ahead and you think that you can just go ahead and, this is where railroading comes in. And this is where I think that the cast and the FBI is going to get dismantled. And there's going to be a lot of cases that could potentially come back into the appellate arena due to what's going to be proven, I believe, in this case, which is that the FBI has manipulated and distorted cast, viz, and all this bullshit to papow on defendants who they believe are guilty, but they're trying to add evidence where evidence isn't like sought. Like it's not what somebody is testifying to is not accurate. But defendants don't even have a chance to. Majority of defendants don't even have a chance to combat that because they can't even afford a fucking defense. So, the PowerPoint is vague and makes it impossible to determine what Special Agent Balance is claiming. Thus, the additional summary does not remedy the lack of disclosure, leaving Mr. Kohberger an inability to prepare and meet the constitutional protection of confrontation. Testimony must be prohibited pursuant to Idaho. So they're saying, hey, you didn't meet your disclosures. Like if you want this guy to be labeled as an expert, okay, he's not. Jennings was told this. So I'm curious to see. Obviously, they're going to be having a long old talk about it. So they want Nick Balance. He is not testifying. Like the defense is saying, you're not testifying as an expert. You didn't disclose this. You didn't disclose that. It's past the deadline. Okay. And when we go to oral argue this, we're also going to argue other parts about it. Number 3, S3 and S4, Mr. and Mrs. Barnhart. Now, the only people that I know that are Barnhart, like a Mr. and a Mrs. Like that's interesting. Well, their testimony must exclude everything other than specifically disclosed, including purported habit evidence. The state has not produced a report specifying what habits are referred to. No expert opinion has been disclosed. Mr. Kohberger cannot prepare to confront purported evidence against him that is undisclosed. I have no idea who Mr. and Mrs. Barnhart are, but I do know of the people on the Idaho's campus that are Mr. and Mrs. Barnhart. So I don't know, is that them? Habit evidence, I don't know. So again, they're saying, yeah, Mr. and Mrs. Barnhart, bye. Goodbye. I don't understand how they would be listed as, experts, though. Maybe they just don't want to touch my all. Anyways, okay, here we go. Number 4, Mr. Cox. Gotta love a good Coxman. Mr. Cox will be testifying to Amazon. And his testimony, as far as the defense is concerned, must be excluded because no opinion or full analysis of the data has been provided. It appears Mr. Cox has credentials to gather data at Amazon, but nothing disclosed indicates he has the expertise to form an opinion on data. And if he does have an opinion based on analysis, neither the analysis or opinion has been disclosed. The full amount of raw data received from Amazon has never been disclosed. That blew me away, y'all. Okay, this accusation right here. How is that not a discovery violation? Only narrow dates with some purchases have been disclosed, despite warrants seeking very broad materials over the span of a year, and according to warrant returns, produced. So like they know that they exist because we have the warrant returns. Excel spreadsheets, apparently relied on by the state, have quote unquote redacted purchases without explanation. This is going to get, we're going to get more into this as I go into the different motion limines, but Mr. Cox, the state wants Mr. Cox to testify to Bryan Kohberger's clicks on Amazon. I was up all night till like 3 or 4 in the morning because it intrigued me because of what I do with YouTube and talking about algorithms and what gets sent our way. You know, when you get this recommended video to watch, or when people are hashtagging or adding my channel at Truth and Transparency, hashtagging my name, hashtagging my channel name, hashtagging names of my videos. I did it when I went to court, and it's actually in court. I don't know, we basically set precedent in Colorado, but when you use the @ symbol, it's a form of contact. Like, you are contacting me. But also what it does is it messes with my algorithm. And when people are clicking on your stuff and watching you or sharing your videos, you then will start surfacing in their algorithm, and then they're in your algorithm. So I was really intrigued with listening to this because of the AI new aspect of things. So we'll get into it. But there's this Excel spreadsheet that the state or that the defense is alleging that apparently is going to be relied on by the state, but the state has redacted purchases without explanation. Context for purchases at least 6 months prior to what has been provided are critical for drawing opinions. So they think that they're just going to come up in here and on a couple days or one day say Bryan Kohberger clicked on this. Okay. There is no full disclosure or analysis of click stream history that spans the scope of the multiple warrants and subpoenas. There is no full Amazon advertising history. AI-driven recommendations or cookies disclosed or analyzed. The identification of the devices used is not disclosed or analyzed. No cart or wish list data is disclosed or analyzed. No omni-channel tracking. This is when I was like, I was like, oh, I got to look into this because it was interesting for what I do. Right here. No omni-channel tracking data or platforms are disclosed. Platforms, like YouTube is a platform. Analyzed, or big one here is for a household. This Amazon account was used by the entire Kohberger family. Okay. So, and I was like, oh, interesting. Now, again, this is the defense's claim. So, but this Amazon account was used by the household of the Kohbergers, or multiple members use the same Amazon account. The search warrant request account-wide data, including linked accounts and device identifiers for a year span. That has not been produced, analyzed, or explained as an expert opinion. Mr. Kohberger cannot prepare to confront purported evidence against him that is undisclosed and lacks context. Context is very, very important. I argued it when somebody wanted to clip little portions of me saying, a bunch of different words and then putting them all in a video and trying to make it seem like that was the entirety of a video. I said, get the fuck up out of here. There is something called the incompleteness of evidence rule, and it's for just that. The state has produced a select portion of a whole record. The state has cherry-picked information. Now, those of you guys that think that Ann Taylor has cherry-picked in this case, you are now sorely mistaken, because I'll tell you what. If she in fact did and then used the word cherry-picked in a motion, then she's a complete idiot. Okay? You're not going to cherry-pick and then accuse somebody else of cherry-picking and writing that in a document. Okay? That will be so not well taken by the judge. Like, you wouldn't even do it. Is that right? You know it. He cannot determine if the state is asserting a direct search or review of items algorithmically suggested through Amazon's ad system. Testimony must be prohibited pursuant to Idaho Criminal Rule 16. And goes on with, the subject matter of this testimony is challenged separately in the motion limiting number 15, and that's what we're going to go to next. So, where it's sweet. So, yeah. Number 7 here. The defense is saying, hey, Michael Douglas, keep sticking to videos and movies. Okay. Any opinion testimony must be excluded. All arguments set forth in Shane Cox in paragraph 4 above are incorporated for Michael Douglas as it relates to any testimony about Amazon and clicks. The state intends to use Agent Douglas as an Amazon expert. Woohoo! That is wild. Without any explanation other than what a cherry-picked group of records might show. The state has produced some records and reports relating to documents collected by this witness. Not all raw data has been disclosed. No explanation of underlying raw data or how it was analyzed. For me, I want to know, that's the methodology, how it was analyzed has been disclosed. The state has not produced a summary of an opinion about the purported meaning of such documents. So just because that's like someone saying to me, when they say, well, Lana, what's your theory? What's your theory? What's your theory? You talk about these cases, but you never give a theory. Yeah, exactly. Think about that. Think about me just putting in a CV that says badass YouTuber, bomb-ass researcher, and here's just the material that I used to come to my conclusions and findings, but I don't tell you my conclusions and findings. Wild. So, again, the state has not produced a summary of an opinion. So what's your opinion, Lana, about the purported meaning of such documents? Opinion testimony must be prohibited pursuant to Idaho Criminal Rule 16. Also, the court's scheduling order. They keep saying that because they're going to hone in on that, because Hitler was letting Ashley Jennings know that if you think that you're going to do this shit, you're not. Like, what are these people, what are they going to testify to in court? You have to know what your case is. Like, what do you think these people are going to testify to? Next up. This is S15 through S25. And these are going to be, and I love how they're already labeling them. It's really good for what I'm trying to do. Be organized for this trial, which is going to be off the chains. This is all the ISP lab experts. They're expert witnesses. I cannot believe that there's like a bunch of them in the Delphi case, okay, that spanned the course of, by the time I went to trial, 7 years. There was one person and only one person that testified to the DNA, that testified to doing anything in the lab, because that's how Indiana does it. They don't have multiple people working on stuff so that, cross-contamination, or like, it's just the one person. And for me, that makes sense. And maybe to use somebody as like to peer review it or something like that. But here, when I saw that Idaho State laboratory expert witnesses are anticipated, I'm like, wow, how many? To the extent their opinions are limited to the reports authored by them. Amazing. You want to know why you would have to put this in there? Because guess what they think in Idaho? It just happened in the Jennifer Drake civil trial. They had the lead detective from Idaho State Police testifying in a civil proceeding to the findings of an ME. I about died. I about literally died. And they thought that they could get him to be able to testify because he could answer some vocabulary questions. So don't put anything past Idaho, and you got to make sure, here we go. So to the extent that their opinions are limited just to, hey, whatever you did by them and based on their own expert evaluation is not the subject of this motion limiting. So again, News Nation, newsflash, they're not trying to keep out the lab workers and their lab reports. It's, you're not going to testify to anything that you didn't do. So remember, in the suppression hearing, aka the Franks, we got it nailed down. We got Rollins, whatever the hell her name is. She's coming up here. She didn't work on this case. So bye-bye. Bye-bye. She, the lab manager, Sweet Should, remember, she comes out and says that she did not do any work in this case. So testimony through any of these witnesses, other than their own opinions, stated in Idaho State Police forensic laboratory reports, must be prohibited. Boom. Oh, wait, there she is. There she is. Rylene, baby, come on down. Shake it, shake it. Rylene Nolan, S21, has been disclosed. Challenge to her proposed testimony is covered in separate motion limine. And this is going to be, and I think this is one of my favorites too. It's the touch DNA. She thinks she's going to get up there and talk about the definition of touch DNA, but more importantly, how touch DNA is transferred and when it's transferred. And that's like a big no-no in forensic world. So I'm looking forward to explaining that to you guys. So that'll come up. Eric Seat. According to the defense, the expert opinion of this DNA technician provides an explanation of possible testimony regarding a methodology for DNA testing YSTR for which the defense has received no discovery. Fuck a report. We don't even have discovery. Remember that came up in the motion to suppress, or indication that the method has been used in this case. There is no opinion disclosed other than, quote unquote, because of the large volume of discovery, the state directs the defense to summary reports of the expert's ultimate conclusions, which can be found in Lab Report 3. Lab Report 3. These are Bates pages, which means it's just, you're going to go to that page. And in this section here, these 10 pages, Lab Report 3 in those pages is DNA data of an alternate suspect, but no ultimate opinion or result is specified. Okay, and that's going to come up. That has to do with motion limine number 2, Exhibit 1, ISP Lab Report 3, which is testimony through this witness, other than that relating to an alternate perpetrator, must be prohibited pursuant to Idaho Criminal Rule 16, the court's scheduling order. This is going to go to male versus female, I'm telling you. Again, come on in. Truth and transparency. Appreciate you being here this morning. Thumbs up the video. Thumbs it down. Use a thumb. Don't be a lazy bum. Oh, S10, S13, and S14. This is Maori, Tanzola, and Neil Rig. Freemason right there. Huge Freemason right there. I mean, we're talking huge daddy Freemason right there. The state has provided, I know him from the Moore case. The state has provided no disclosure of any expert opinions related to 67 electronic devices. Can you believe that we have no disclosures by any expert witness? Like, this is where your forensic phone people out there, like Micah Sturgis in like the Murdoch trial, to be disclosing that you're going to talk about the way these, whatever, like, you know, emails that were found, text messages that were found, shit like that. Your step, anything, nothing. 67 electronic devices and third-party data collected during the investigation. The state has failed to identify what portions of the electronic device data, digital data, and or third-party search warrant return data will be presented. The state has failed to disclose any expert opinion about what any analysis of the devices or data depicts. The state has disclosed in discovery a new report stating further examination is taking place, and this is on Bryan Kohberger's computer. What the fuck have you guys been doing? You guys, it is 2025. This was in 2022. Motion in limine number 2, exhibit 2. Police report indicating additional analysis of Mr. Kohberger's computer. What? So I was like, damn, they just jerk around over there. Good morning, sleepy goosey girl. Saw that in there. Shake it, mama. So I was like, Jesus, what have y'all been doing? That disclosure came well after the state's discovery deadline, which we know was in September. The report does not contain any sort of opinion. Recently, the state submitted rebuttal expert disclosures. Repeatedly, the state writes that it cannot provide rebuttal as Mr. Kohberger has not provided information about what his experts may say. The state's disclosures would seem to be the proverbial chicken and egg antidote, except in criminal proceedings, the accused has rights under the United States Constitution that, hey, guess what? We have some court proceedings and laws and rules that bind and bound from our proceeding judge here, and they get to pronounce deadlines, okay? As such, the state was required to provide expert opinions to which Mr. Kohberger would rebut. It is your case, Ashley Jennings, okay? Your case. Your case. As such, the state was required to provide expert opinions to which Mr. Kohberger would rebut. The state's disclosures remain vague. Mr. Kohberger cannot prepare to confront purported evidence that is undisclosed. The electronic evidence in this case is critical, and the state is impeding the defense from being able to prepare to confront evidence or use evidence in Mr. Kohberger's capital trial. Let's just put it to you guys this way. When there's they have nothing, you guys. This is so evident. You have the DNA, okay? You have the DNA on the sheath, and now you're going to have to tell and explain to the world, aka the jury, how the sheath got there. That's the state, and they're going to talk about that's the state's job, is to prove why that sheath is there, how it got there, how, and that touch DNA that we're going to talk about, that it's not from transfer or secondary. So I think Ashley Jennings doesn't understand here that it's their case. Okay, it's your case. You shouldn't need to know anything about who I'm going to have. Your people should be so fucking solid that it doesn't fucking matter. Okay? Obviously, we're going to have experts that once we see what you're going to say, okay, this is what they're claiming, you're going to go shop around and see what other experts out there could say something different. You know what I mean? That's how that works. It's wild to me. Testimony must be prohibited pursuant to Idaho criminal. Again, I would be just jumping on this heavily. Okay, this was fun. You guys, I don't know if you guys know this, but Payne did a barking test, and now his cohort and partner in crime, Detective Gilbertson from the Idaho State Police detectives, out there in District 1, he did a count test. Can't make this up. Detective Gilbertson. The state did not disclose Detective Gilbertson in their initial disclosures, but instead listed him as a rebuttal witness. The state did not identify any specific expert or opinion that the detective will rebut. Thus, the court should exclude this testimony as outside the scope of rebuttal. And this is the first time we're hearing about this outside the scope. And so I highlighted because I was like, oh, I know exactly where they're going with this. You cannot be a rebuttal witness, okay, and have something in your rebuttal that Bryan Kohberger and his experts didn't disclose that they're going to be even going that route because it would be outside the scope of what the direct examination of Bryan Kohberger's motherfucking experts would even be talking about. Okay? Moreover, the court should exclude the testimony under 403B, the relevancy. The relevancy of this testimony is minimal at best and carries a serious risk of juror confusion. I'm thinking, like, what the hell is this man going to testify to? The detective walked alone through a house that he is intimately familiar with in the middle of broad daylight more than 1 week after the house had been vacated and changed significantly due to a homicide investigation. He simply counted out loud upon entering rooms. This is a far, far cry from what the state alleges occurred. I about fell out of my bed. I said, he did what? He went into rooms and was counting? He simply counted out loud upon entering rooms. 1, 2, 3, 4, 5, 6. I mean, what is he talking about? Not that he was screaming. He was just counting. Counting for what? Okay, so this is a far, far cry from what the state is alleging occurred. You know, there's a murder. 4. Additionally, Mr. Kohberger attempted to learn more about the experiment through discovery. So they have this, what do you call it? They get this report at some point, and where they're like, oh my God, Jay calls up Ann and is like, dude, did you read supplemental report 64? Gilbertson was in rooms, like, I don't know, what, counting? Did you see that? Yeah, let's ask for more. So we'll do one of our, I got supplemental 14 going out. So I'll put that in there to say we want, any video, any audio from his experiment. So they write up their little supplemental and then they add in here. So during the discovery phase, Mr. Kohberger attempted to learn more about this experiment through discovery. He saw things such as recordings or photographs of the timed run or written notes taken and documentation just during this experiment. Guess what happened on that discovery return? Nothing was provided in discovery. The prosecution stated those items did not exist. And they want to fucking use them. I got the fuck. There you go. I just want a shirt that says do not exist. Did not exist. I'm sorry, just what did not exist on the back of my shirt. That's all I want. Did not exist. Yes, that would be C. Number 2, exhibit 3 discovery request. So, in response, this is defenses. It's in a 9th supplemental discovery request, and it was item 211, and states 8th supplemental discovery response, item 2111. And she's saying when you go and look at that, you're going to see that they say that that item does not exist. Okay. Now, I can't believe that somebody would take the time to do an experiment and not document their work, not record it, right? You're going to have your phone. So you're going to be audio, video. You just start recording on your phone. That's what you do. But here, again, does not exist. So this is for rebuttal. This is for rebuttal. Rebuttal to what? What do you think Ann's people are going to say? Well, clearly what I think is going to happen is Ann people, they're going to say stuff like, how did nobody hear anybody getting brutally stabbed and murdered when you're in, I don't know, Dylan's bedroom? And when people are like, where Xana's room's located, what, the stairs, right outside. I mean, what? But their experiment was to count? I don't know. So finally, the court should exclude this testimony because it violates Mr. Kohberger's due process rights. The house, and this is just like chef's kiss, the house has been torn down. The defense cannot now effectively rebut this inflammatory and minimally relevant testimony. So you want to talk about why Ann was okay? Yep, go ahead. We're fine with tearing down the house. Go take a look at when Supplemental 9 was produced to ask, and the dates of these. And I'm really curious on those dates. So it was like, we don't have the house anymore, so we don't even have a chance to fuck with this. Now, Gary Dawson, number 11. This expert was disclosed for the very first time in the state's rebuttal experts. He is a toxicology expert. Mr. Kohberger did not disclose an expert related to toxicology. This expert is not a rebuttal expert and should be excluded from trial. Did they try to squeeze Gary Dawson in? Did they try to get him in on some fancy way? You guys. Okay, when you have a rebuttal witness is to when somebody discloses who, again, these are who my experts are going to be, okay? And then they disclose who their experts are going to be. Then after I get to see who your experts are and you get to see who my experts are, we can then submit, there is a time frame for rebuttal witnesses. And then you have that, there's a deadline for that. Mr. Kohberger does not have and did not disclose a toxicology expert. Now, what they're going to probably say is, no, but you have somebody that's your ME can talk about that. So then this is our rebuttal to that. And it's just like, well, what? That's going to be their argument, just so you know. That's what's coming. David Middleman. Now this is going to get real interesting. This expert was disclosed as a rebuttal expert relating to IgG matters. Do you know who this man is, you guys? He runs Othram. This expert is addressed in a separate motion because Ann's like, I'm going to handle that ass. Okay? Now, it is in the interest of fairness, justice, and judicial economy to exclude the listed experts. And I highlighted judicial economy for a reason. Because late disclosed expert opinions do not allow the defense sufficient opportunity to conduct the follow-up investigation necessary and put the defense at a significant disadvantage. The state has turned over numerous generic responses identifying expert names, but only vaguely describing the subject matter that they will testify to. The disclosures do not identify the content of the anticipated testimony, nor the documents or evidence that the expert relied on to reach said conclusion. As federal courts apply, so I'm not going to read that, but other courts analyzing the federal rules have explained why late disclosures are so prejudicial to the opposing party. Hey, I said, look at this, even in the civil context, I'm going to use this case law. Thank you so much. The court finds that just simply reciting the names of experts, you guys, does not prevent surprise by the opponent. So, and specifically noted that prejudice that occurs when one party complies with the deadline and the other party does not, as in this case. The state's experts have had the benefit of being in a position to examine and rebut the opinions set forth by defendants' experts in their initial reports. This is a significant litigation advantage. It totally is. The party who failed to comply with the deadline set forth several reasons why the defense was not prejudiced, but the court observed that forcing the innocent party to complete everything necessary on an expedited timeline was inherently prejudicial to their case. And then citing, the court then noted the importance of parties complying with the scheduling order in good faith, which we're going to talk about here in a little bit. A scheduling order, so Hitler should get his rocks off here because they're empowering him. Thus, a scheduling order is not a frivolous piece of paper, okay? Your scheduling order, you said very, like, adamantly that, hey, these are the deadlines. When Hitler speaks, Hitler whips, okay? And so the defense is reminding him of that. So the same analysis is applicable here and carries even more force. Mr. Kohberger is a capital defendant who is entitled to his day in court without undue delay by the prosecution. He is entitled to, quote unquote, heightened standard of reliability because prosecutors are seeking his execution. And I question why the state is even fucking around with this, because do you want to be in appeals for the, like, ever and or give this man a chance to get out or have a new trial, like, when you're just like, why fuck around? That's what I don't get. And again, maybe they're not, but we'll see. Ann Taylor's just people just say Ann Taylor's just doing her job. I believe that Ann Taylor's playing the long game because she knew that they weren't being honest in the beginning, and the only way to prove dishonesty, okay, is the court's going to believe you, until you can get to a certain point that you can then use past proceedings to impeach heavily those liars. So we'll see. The state has the resources of dozens, if not hundreds, of people working on its behalf from various state and federal agencies. It has the advantage of technology that is available only to law enforcement agencies and not to the defense. It is bringing the full resources of the state of Idaho to bear, alongside assistance from the federal government. While Mr. Kohberger has a defense team consisting of 3 attorneys, one investigator, and 1 mitigation specialist, who must not only review all of the state's evidence, but conduct an independent investigation into both the circumstances of the crime and into Mr. Kohberger's entire life's history. The pre-existence resources disparity must be taken into account when assessing the additional tactical advantages that the state has improperly obtained. Notably, the state did not seek modification of the scheduling order to allow for a later disclosure deadline, which would have equally applied to the defense and would not have given the prosecution a tactical advantage. It is fundamentally unfair for the state to shriek the court's order and reap the tactical advantages of being able to review the defense's expert opinions before making their initial disclosures, in addition to the already existing advantage in resources. The court should exclude the listed expert reports and evidence listed above and preclude the death penalty at the trial in order to cure some measure of the prejudice to Mr. Kohberger. Ann Taylor will be arguing this motion. So right here is where the first time that you're going to see, like, listen, we're going to keep asking that you cure it some way, somehow. First of all, they didn't make their deadline, but that still isn't good enough because they still had our experts' opinions first. And now they're trying to use rebuttal witnesses and going to try to, I believe, sneak them in as their own experts. Unless you're on top of it and you pay attention to everything that they're doing, that's what it would look like. Next up, the use of the term murder. Really quick. At first I thought this was crazy, but then I said, I see where they're going with this. It's very simple that they just don't want buy-in through the attorneys of Bryan Kohberger. We don't want it to be like this. We are asking for an order prohibiting the use of words murder, murdered, murder weapon, and similar forms of the word murder applied to Bryan Kohberger during the trial of this matter. It's applied to Bryan Kohberger. He has a presumption of innocence. And first of all, we don't have a murder weapon, okay? We have a sheath. So the motion is not seeking that you cannot use, like we're not preventing you from using the word murder on its varying forms in the charging documents or jury instructions. We are asking, this motion is made pursuant to Idaho Rules 403, 701, 702, where the killings is at issue are murder as alleged committed by Bryan Kohberger or by an alternate suspect or someone still unknown is the ultimate issue. Each side will present this argument to the jury. It is a matter of fact to be found by the jury after the court instructions. The jury will, with the applicable instructions, to label Mr. Kohberger as a murderer, the alleged weapon consistent with an empty sheath as a murder weapon, or to assert that any of the four decedents was murdered by Mr. Kohberger denies him the right of a fair trial because he has the right to be presumed innocent. So I think that that is interesting. And I think that it should be upheld. Again, the people that don't read and don't understand the motion because they don't read would think that this means something completely entirely different. So it's right there. But they keep talking about this alternative suspect. They had a main suspect, y'all. We're going to talk about it. So it is improper for the prosecution to express a personal belief unless the comment is based solely on inference, so expert testimony that concerns conclusions or opinions that the average juror is qualified to draw from the facts utilizing the juror's common sense and normal experience is inadmissible. Basically, you're not going to call Bryan Kohberger a murderer. That's what it's basically. He has the right to be presumed innocent. Using the term sociopath, psychopath, the defense is asking for an order prohibiting the state from name calling. If this ain't what we teach in elementary school, okay, there'll be no name calling in my courtroom, damn it. You're not going to be referring to my client as a psychopath, sociopath. You understand? IRE 403 allows exclusion of evidence that is unfairly prejudicial to a party. So, I mean, I think it'd be like, I don't think they're going to do it anyways, but I mean, who knows? Maybe Ann Taylor's just, I got to cover all bases. Maybe it's because of the media. So maybe both of these are because of the media. Maybe this is a way for Ann to use the goddamn public record to say, why don't you guys fucking learn about the world, and everybody has a constitutional right to the presumption of innocence. And the media, you guys just all suck a big one. So, ooh, yeah, here we go. This is what everyone's been waiting to talk about. Inconclusive data. News Nation, please listen up. News Nation. Comes now Bryan C. Kohberger by and through his attorney of record and hereby moves this court for an order limiting. Do you guys not know? Here you go. Limiting testimony. Do you see this, you sons of bitches? You worthless. Looks like uneducated propaganda POSs. Limiting testimony. Where does it say that I want the DNA underneath the fingernails of Maddie tossed? What a bunch of clowns. Okay. Again, we are asking for an order limiting testimony about the statistical analysis of item Q 13.1, fingernail scrapings. Allowing such testimony would violate Mr. Kohberger's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. This motion is based on the 5th, 6th, and 14th Amendment. Statement of facts. Yeah, they titled the video Bryan Kohberger breaking DNA found under victim's DNA. Exactly. Exactly. It is absolutely crazy. Thank you so much there, keyboard crime fighter. Thank you for the real answers. Yeah, it just really takes me reading. So let me tell you all what happened at the grand jury. Let me tell you how sick this is. Guilty, innocent, I don't care. I'm talking about tactics. In grand jury testimony, Jade Miller testified as to the results of testing done on item Q13.1, which was a swab of the left fingernail clippings from Madison Mogen. The data consisted of 3-person mixture. Holy shit, everybody should be like, holy shit. 3-person mixture. The statistic, comma, the likelihood ratio, which is LR, likely ratio, LR, was calculated assuming, now look at this word, assuming. When you assume, you make an ass out of you and me. So what they did is they assumed, they did an experiment, okay? The likely ratio was calculated assuming that MM, Madison Mogen, was a contributor to her own fingernails, okay? Which I have totally things to say about that. Miller testified that MM as followed, and that gets redacted. Now, the data, and this is assuming that MM is one of the contributors to one of the 3-person mixture. This is what happened in the Delphi case. There were all these mixtures, but it was like 5 and 6, 3, 4, 5, 6. Okay. And it was in the blood. And I'm like, how is there 5 or 6 mixtures in the blood? When they were, taking the evidence, and when they were it was like they could not separate 5. There was 5 to 6 basically persons that were the mixture of this sample. And I'm like, how is the jury not just like, okay, not guilty? Jeez. So here, the first thing that they did is they just assumed, okay, we're going to say that Madison Mogen is one of those 3. They don't know if that's true, though. You understand? Is that right? The data from that sample was redacted as to Mr. Kohberger. Grand jury transcripts at 365. 366. Miller testified that inconclusive means that an analysis is grand jury transcript at 366. Miller went on to explain that the likely ratio for Mr. Kohberger at grand jury transcript 367. Okay. Argument. The use of misleading language confuses and misleads the finder of fact and is barred by the rules 402 and 403, as well as due process, in that the evidence is overly prejudicial. The erroneous admission of irrelevant and prejudicial evidence will offend due process when it renders a trial fundamentally unfair. Here, expanding beyond the language of the report would prejudice Mr. Kohberger. Okay? We don't want this. Remember, we're going to go back to what is this all about? It is limiting the testimony, right? Limiting testimony. We're making sure that nobody's going to get up on that stand and start spouting off shit that is, whoa. That is not even, that is not even right. So we're getting ahead of it because we know how they play. So here, expanding beyond the language of this report would prejudice Mr. Kohberger in that it might allow the jury, because let's be honest, we can't trust juries right now. I don't know what they're doing when average citizens are being asked to go be a juror. Here you go. Don't know what's the thought process going on, but hey. But it may allow the jury to infer that the inconclusive data would mean that he might be included in this wild-ass experiment. LRs are different from traditional statistics. Again, likely ratio, we learned this in 5th grade, that the courts and juries are used to seeing and hearing. The LR is a comparison of hypotheses. It is not a statement of identity or probability of identity. We learned all about probability in grade school. If you have a dice and you roll it 3 times, what's the probability that you are going to get a 6 on 1 out of 3 of those rolls? What's the probability of that happening? That's statistics, man. It simply asks the question, given the data, which hypothesis tested is more likely? It's a this or that. For item Q 13.1, both hypotheses tested for each individual assumed that MM's DNA was present, and that's flawed. That is so flawed. Why didn't you have one that wasn't? So when the lab generated the likely ratio laid out above, the hypotheses tested were these. MM, Kaylee, and I'm thinking, why would Kaylee's, DNA be underneath her? Like, just interesting that they, okay. MM, KG, and 1 unknown unrelated person versus MM and 2 unrelated persons. This comparison was done for all of the individuals listed in report 7, which is their little who they were looking into. Like, these are our suspects. So this comparison was done for all the individuals listed in report 7 and for Mr. Kohberger in report 26. And we're going to talk about that. That footer is motion limiting number 5, exhibit 1, ISP lab report 7 and 26. So we're going to come back. At the ISP lab, any number greater than 100 is considered a conclusive result indicating inclusion. Any number less than 0.01 is considered an conclusive result indicating exclusion. Thus, if an LR falls within the range of 0.01 to 100, the lab cannot draw any conclusions, and the data is reported as inconclusive. And it's like, wow, what a fucking range. Like, everybody's going to be inconclusive unless you are the person, you motherfucking morons. In her testimony, Miller did not provide a full context to the analysis. The lab reported a series of LRs for items 13.1, including an LR of 0.3999 for this person, redacted, and that's somebody else. This person, for this person, and this for this person. Lab report number 7 at 3, all of these individuals sit in the same shoes as Mr. Kohberger, namely that the LR is exclusionary, but falls in the range of inconclusive. So now this is where I was blown away. Of interest is that when an LR was calculated for blank, comma, blank, I'm interested in this. Of interest is that when an LR was calculated for, thus Mr. Kohberger's inconclusive LR is similar to almost every other person for whom an LR was generated and focusing on his quote-unquote inconclusive LR would mislead the jury. And then I was like, oh, now I get it. That means that Bryan's, with these numbers that they just rattled off here, Bryan's is, these numbers are lower. LR would mislead the jury in that it implies that the LR means that Mr. Kohberger's DNA might be present in the sample, and that is we're not allowing that. We're not allowing that. The court should exclude testimony such as, and it's redacted because it was said at the grand jury. And then here is where it's the most important part. Hey, News Nation. Hey, trial watchers. Ready? Here it is. More importantly, Mr. Kohberger has disclosed that through further independent laboratory testing, he disclosed it. Like, he disclosed it to them that through further independent laboratory testing, he is eliminated as a contributor to 13.1, which means, holy shit, we have unknown blood outside the house sample, unknown blood, male, inside the house. Now we have potentially three unknown persons underneath the fingernails of Madison Mogen, and it's not Bryan Kohberger. When Mr. Kohberger sought to overturn, remember, the grand jury indictment, because remember, they were going to have a preliminary hearing, and then they had to go secret grand jury, like, holy shit, oh my God. They all flipped. So when Mr. Kohberger sought to overturn the grand jury indictment, he argued that Miller's testimony was inadmissible and misleading. The state argued that the testimony, you guys, was presented to the grand jury as exculpatory in an effort to elicit favorable evidence for Mr. Kohberger. Are you kidding me? And this is how News Nation interprets this. Wait, this whole freaking report, y'all. Woo! This is exculpatory for Mr. Kohberger. We just can't have some idiot named Jada Miller on the fucking stand speaking how she spoke in front of the grand jury. That's what we're limiting. We're not allowing her to mislead the jury with this fucking bullshit that they did. We're going to cross her up like a mofo, don't worry. But we're going to make sure that Jada Miller, JM, another Jennifer McCabe over here, JM, isn't going to just go up there and think that she can say what she said to the grand jury. It's not happening. We're not, the defense isn't like, you're not using the DNA underneath the fingernails. Oh my God, no. I mean, what a bunch of ass clowns. Who's reading? How do those people have jobs? How are you interviewing somebody with, I don't know, looked like 2 consecutive months of straight Botox and talking about a document that, what? And then that's why they want to have people like me on there. I'd be like, what are y'all talking about? They're not excluding this. They don't want to, excuse me? This is this isn't helping the state at all. It doesn't hurt Bryan Kohberger. This is actually to show that his fingernails are not, or his skin cells, DNA, it's not underneath Maddie's fingernails. And JLR, love you to death. Those titles of what he wrote the other day, I just couldn't even believe it. But JLR's at least, I bet you if I was to write him and say, hey, I think you need to retract that, I bet you he'd consider it, and he probably would. The defense, they do want this evidence presented. They don't want this evidence twisted. So, but I cannot believe that the state said that they offered this testimony. Hey, we were being fair to Mr. Kohberger. This was for purposes to provide some exculpatory evidence. So here, hey, guess what, News Nation? The state's admitting that this testing is exculpatory for Mr. Kohberger. That's how y'all should be saying that. That's how everybody, all these headlines should be like, the state admits that there's exculpatory evidence for Bryan Kohberger. That's going to be my headline tonight. Let's see how many people join in. Because that's exactly what it says. You know what I started realizing is it's like, hey, if we bring on people that really don't know the case on our media platform, we'll let them spread the misinformation, so it won't technically be like us spreading it. We'll just let our correspondents, we'll just let our guests do it. You know, it's like a reoccurring theme. So the independent lab testing conducted by the defense related to item 13.1 is indeed exculpatory. Mr. Kohberger is excluded, and the state should be precluded from misleading the jury in any way. That is what this is all about. Period. And all it took was to literally read the first sentence. Comes now Bryan C. Kohberger by and through his attorney of record and hereby moves the court for an order limiting testimony that Jada Miller can't be spitting some straight up slime. That's all. And we don't have all this time to cross her up, and we're not going to do all that. Oh, here it is. Let's see. Now, Miss Rollin here. Rylene Nolan. We're not going to let you speak a damn thing about touch and contact DNA. So, excluding the testimony of Rylene Nolan and any testimony, number one, referencing the term touch or contact, and two, so you're not going to be saying touch or contact DNA, or two, purporting to be an opinion of the meanings or mechanisms for DNA being placed on the sheath by any witness called to testify about DNA. So this was so well written by Becca Barlow, like tits amazing. Both the term touch or contact DNA or any opinion regarding how DNA ends up on an item is misleading in that it assumes facts that must be proven, would be confusing to the jury, and waste substantial time in debunking. I highlighted that because now we have professionals using the word debunk. It is now officially coming into the courtroom. So would be a substantial waste of time debunking the testimony of an expert that is outside the peer review of the field expertise and qualifications. Furthermore, the opinions of this expert has not been disclosed to Mr. Kohberger, as set forth below, and how and when of DNA arriving on an object cannot be scientifically determined. So this was huge. So she's not going to be talking about the how and when, or nobody is, of DNA arriving on an object. And if you guys want to go back and listen to Gabriela Vargas, we talk about that. She talks about that. And it's about nobody can determine the how and when that DNA would arrive on an object. It cannot be scientifically determined and is not the proper subject of expert testimony. So, like, you're not getting this in. This is why Becca Barlow's on the ticket. The use of this language confuses and misleads the finder of fact and is barred by the rules 402, 403, as well as due process. So I highlight here, and the exact location of the sheath is unclear in both photographs of the room and in the written description of its location. So this was written after we just had that whole big, suppression hearing. And the defense is saying, and I was like, there's only 2 pictures out of 3 or 4,000. The exact location of the sheath is unclear. The body cam footage of one of the first responding officers on scene shows the sheath tucked under the covers next to Miss Mogan. So, relevant facts. A knife sheath that was recovered tucked under the covers next to Miss Mogan at 1122 King Road, Moscow, Idaho, on November 13th, 2022. And then that's where that photo that I just read. The sheath was tested using standard DNA STR methods by the Idaho State Police Lab. And then that became item Q1.1, which was going to be talked about for a long time. So item Q1.1, and that's your third footer here. While item Q1.1 was tested for DNA, this is so important. It was never subjected to standard biological testing for the presence of blood or saliva. That is where, so again, think about this. It was not tested. So while the item was tested for DNA, because they did the swab, it was never subjected to standard biological testing for the presence of blood or saliva. In one exchange of emails, Rilene Nolan described the swabbing as being of the leather strap and internal metal area of the snap. The snap itself may not have been swabbed at all for DNA. The defense has no ability to retest based on the fingerprint process on the sheath and that happened after it. Because of that. So the item Q1.1 is your sheath here. A swab from the sheath resulted in a single source male profile. The profile was uploaded to the CODIS DNA database and resulted in, before we go there, the other two, this is so to prove everybody like this right here in black and white. The other two male profiles identified in the ISP lab reports as unknown male B and unknown D, they were never run through CODIS or subjected to any IgG testing. The defense has never received an explanation as to why these two male profiles were not further investigated. And that's the blood on the rail, and that's the blood outside in the gloves. Just a reminder. Some people want to say that there's these answers out there that say why or there wasn't enough or whatever. The defense is putting it in paper, black and white, saying that's all noise because we don't know. There's been no explanation as to why none of that happened. Why didn't you try to do IgG with those? And why didn't you try to upload it to CODIS? And we, myself and Bella, have made and have talked to people. And in order to upload to CODIS, it has to be foreign to that area, to that house. You just can't go around uploading. And so I'm curious as to say they're going to say that DNA is not foreign when they took in a bunch of samples to do comparison and to eliminate things. So I think that's interesting. Anyways, the government has indicated that Rilene Nolan from the Idaho State Police Lab will testify as follows. And I about fell over. Miss Nolan will also testify to touch DNA and transfer of DNA. Specifically, Nolan will testify to the characteristics and nature of touch DNA, including how it is deposited and transferred to an item of evidence, the methods used to calculate and preserve touch DNA samples from items of evidence, the procedures and protocols used by forensic scientists to extract and analyze touch DNA, the manner in which results from touch DNA samples are interpreted, and the reliability of touch DNA analysis and its acceptability in the field of forensic science. Nolan will also testify to the potential for DNA to transfer between an individual and an object, including the distinction between primary and secondary transfer and the factors influencing the likelihood of transfer. And I'm already stating it here is I believe that Hitler is going to say, well, can't cross-examination, just cure this, or you're going to have your expert and they're going to say, and here, this is where Becca Barlow is going to be able to argue this and say, no, let me explain as to why. No. So on February 17th, first of all, February 17th is literally just what? A couple weeks ago. On February 17th, 2025, the state produced a second round of disclosures, including one from Ms. Nolan. It was Exhibit S-11. As with the first disclosures, the focus of this second disclosure is touch/contact DNA and direct versus indirect transfer. Although conceding that currently DNA technology cannot conclusively answer the question, the state offers the following opinion. Many complicated factors can influence the likelihood of transfer DNA and the presence of the transfer DNA, blah, blah, blah. Current DNA technologies cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism. Okay, that's really important. So it is possible the DNA detected on M2022, this is the case number, item 1.1, resulted from secondary transfer. However, based on Nolan's training and experience, it is her opinion, given the quantity of DNA detected on that item, which is right here, and given the DNA profile obtained is single source, it is more likely the result of direct transfer. Okay. This is now, well, first of all, the government has not indicated what her opinion on any of these matters is, leaving the defense as substantial disadvantage as to properly challenge the testimony. And this came at right here, as to what's your this we get that this is what you're going to testify to, but to this new report, which comes after this, and what's this? What is this? There's nothing that they've given us about this. So that's what that's about. If the court is inclined to deny this motion, Mr. Kohberger would ask for the court to hold an evidentiary hearing. Hell yes. Because guess what? We need to explore Ms. Nolan's potential testimony in this regard, because you didn't disclose it. Now, the argument, and it's a really good argument because they're right, and they catch the state lying. The terms touch and contact DNA came into use as the forensic community shifted from the testing of obvious identifiable stains such as blood or semen to samples that cannot be identified via a biological test based on the increasing sensitivity of DNA tests. Samples such as swabbing from the steering wheel of a car that was been, carjacked, or a window jam in a burglary were collected and tested on the theory that a person would have come in contact with the object and left DNA behind in the form of skin or other cells. Hence the term touch or contact. The forensic community began to conduct research into the question of how DNA in the form of biological material moves in the environment. And this research led to the conclusion that it is impossible to determine how a particular deposit of DNA came to be on an object. So you're not going to be testifying to how anything, okay? Ms. Nolan, nobody is. In 2013, an article which reviewed the state of the research at the time made of the following conclusions: that full DNA profiles can be recovered from items that have been touched but have been in the vicinity of someone speaking or coughing. It is not possible to establish from the amount of DNA recovered from a surface whether the DNA was deposited there by a single touch or by regular use. It is not possible to use the amount of DNA recovered from an item of interest to inform whether the DNA was deposited by direct or indirect. So right here, Bickabar was like, she's not testifying to this shit. No. This is improper as fuck. All right, this is what Bickabar was saying. Now, The term activity level refers to the question of the when and how of what happened, such as how did the DNA come to be on an object and how long had it been there. Examples of indirect transfer of what might be characterized as touch or contact DNA are numerous and are summarized in the 2 review articles described above. Becca Barlow wants everybody. Oh my God, Karen, I see you, girl. Woo, baby. We got Janet gifting a membership. We got Deborah gifting 5 memberships. Keyboard Crime Fighter, yeah, baby. Yeah. WB. Thank God Ann Taylor is one step ahead of their dirty laundry. Tainting. Karen. Give it out 10 there. Then she goes back to back. $999.99, Karen. Woo! Karen. And then Karen makes sure 10 more people. Woo! So you guys have done 10, 20, 25, 26 people have turned green of the generosity of the people in here. So Big Barlow is basically saying, hey, guess what? Using a less descriptive term such as trace DNA is a more appropriate term to be used in casework when the source and mode of depositing is unknown. So we want you guys to be saying trace DNA. And I think that is so warranted. Okay? Because we don't touch, contact. I mean, that's over prejudicial in my opinion, just by saying it's touch DNA. Because immediately idiots think that it's, you touched it. You touched it. It's touch DNA. You touched it. No, trace DNA. So the terms touch and contact DNA came into use as the forensic community shifted from, I didn't turn my page correctly. So then Becca Barlow fucking puts this amazing diagram up. I'm just like, hell yeah, girl. Hell yeah. And it's like, we have direct, which is primary, then indirect with, it's showing that, then you can have the 1 to 2 to 2, and then this, so then somebody could touch, like, all these different things. All right. And all the way down here is like, woo-wee. So despite this wealth of information, scientific study, the authors concluded that more work is necessary and that the expertise to offer activity level opinions, the how and the when, is beyond the expert of crime lab analysis. So she just freaking cites it all the way to, so no, Miss Nolan. You guys aren't going to come in here and think that you're just going to say what you think you're going to say, okay? Because we have shit to back it up that no. And this is what they're trying to eliminate. Because, again, here's Mr. Hippler. Judge Hippler is going to say, well, can't you just do that on cross, or you're going to have your person? It's like, no, buddy, you can't take the genie back out of the bottle. That's how you're going to argue it. So then in 2024, there's this National Institution of Standards published a document entitled, so basically what Becca Barlow's over here saying is, she's like, what do they think that they're going to, I can't believe that they think that they're going to do this. I can't believe that they think that they're going to testify this way. And we have all of these things out here that says no, like we're not even going to let, like, nobody in the situation, Richard Allen, Karen Reed, no defendant should be subjected to information that their jury would hear that is absolutely fucking erroneous. I'm not gonna clean it. This is an opinion. This is wrong. This is just flat out fucking wrong. So, and so she's citing that all of these standards and organizations that are publishing these documents, they're the ones that you're supposed to, this is where it comes from. Like what your standards are, protocols, what you can't, if you're going to be testifying, how are you going to go against the grain? And that's what Becca Barlow is showing here. So this document was the result of extensive work and years of public review and comment. The expert working group on human factors and forensic DNA interpretation began work in 2020 with the goal of recommending strategies for improving the production, evaluation, and communication of DNA results. The EWG consisted of experts in the fields of forensic DNA and subject to repeated rounds of public comment from the greater forensic community. Most notably for this court, like for our case, the EWG addressed the question of transfer and the ability of experts to proffer opinions. That's what Nolan's, when you're disclosing this stuff, you're proffering. So proffering opinions. So here it is. The EWG is saying, EWG addressed the following question. But a further important question is what activities led to the presence of that DNA? With the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in the crime. Therefore, considering how or when the DNA may have been deposited or why it was not recovered can be vital. And then the best argument for this is when Becca Barlow says, so then she shows again, this is the proposed responses to questions about how or when the DNA was deposited. And there's a bunch of different, questions for speedy purposes. I'll go over this later, but here. The only conclusion that this court can draw is that the opinions regarding the means and manner in which DNA was deposited on an item is not considered a proper topic of expert opinion for a DNA analyst and likely to lead to undue prejudice to Mr. Kohberger and would render his trial fundamentally unfair. This court must exclude the opinion of Ms. Nolan because, as set forth above, an expert cannot offer opinions within their expertise. The expertise of the typical lab analyst is not sufficient to allow them to be considered an expert in the area, the mechanism of DNA transfer. Nolan's disclosure concedes as much in that she acknowledges that the current method cannot conclusively offer an answer to the question of when and how. Nolan cannot be allowed to substitute her judgment in the face of the weight of the forensic community's agreement that the science and literature does not support any analyst testifying about the when and how of transfer. So no, you, Ashley Jennings, but we're just gonna have, she's gonna testify, it was probably happened like this, blah, 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 blah. No, Ashley, it's not happening. It's not happening, Ashley. It's just over there. Duh, it's gotta be the car. It's just over a couple streets, duh. Hello, cars turn around. Okay. This opinion falls outside the norm for forensic DNA experts and would highly be speculative. Given the nature of the opinion proffered and the recommendation in the NIST Human Factors Report, this opinion would be highly speculative. Ready? Here's Lana, which we will be objecting to every time you ask her a question on this. We will be objecting, and we will have a standing objection to calls for speculation, objection calls for speculation, objection calls for speculation. In addition, it would have the tenacity to mislead and confuse the jury and would require undue consumption of time to refute, like I said earlier, with the scientific articles and reports that clearly conflict with the proper testimony. Boom. Just like I said, we're not going to let her come up here and fucking say all this shit that isn't accurate, only to then have to cross-examine. We can cross-examine her, but then have to have the jury hang tight, guys. Wait for our person to come up here to basically say she's on fucking crack cocaine. Okay. In addition, C, this disclosure is not proper rebuttal testimony. Nolan's disclosure contains an opinion that is not rebuttal, but it appears to be the state's theory of the case. This was so good. You guys, the state has a theory, okay? The state, so Nolan's, what would she be rebutting? What's going on here? So, that the DNA from Mr. Kohberger arrived on the knife sheath via direct contact. That's clearly what they're saying. That's their theory, right? Well, guess what? A close reading of the disclosure for Mr. Kohberger's DNA witness, Dr. Ruth Ballard, does not contain any opinion regarding the how and when the DNA arrived on the sheath. This testimony should be excluded. It's like, our people know this. Okay, our people know this. Our guys, they're not testifying to the how and the when because you don't know that. It's improper. So it would be outside the scope as well because, so if you're going to be a rebuttal to Dr. Ruth Ballard, basically Bicka Barlow's over here saying, Ruth Ballard doesn't even mention it, does not contain any opinion regarding the how and the when. So what the fuck is going on? Because guess why Ruth Ballard doesn't say that? Because it's not Ruth Ballard's job. It's the fucking state's job. This court must exclude the use of the term touch or contact DNA. We talked about that. Here, the terms touch and contact are misleading in the fact that the forensic community has determined through empirical research that it is not possible for a DNA expert to testify as to how DNA was deposited on an item. The two terms insinuated that the deposit must have come from direct contact with an object rather than the myriad other possibilities, which is documented in literature. Furthermore, allowing testimony regarding the manner in which the DNA was deposited on the sheath would implicate the same concerns that the use of the two terms touch and contact invoke. The forensic community, it's a consensus, and an extensive body of research shows that the how and when opinions in DNA testing far exceed the experts of a DNA analyst and are not founded in science. In this case, the only DNA evidence that implicates Mr. Kohberger is the DNA found on the sheath found in the residence. Okay? Ready? That means that from the lab reports and notes, as well as recent testimony by Nolan, it appears that at the sample Q1.1 was a swabbing of the leather strap on the sheath, as well as the interior of the snap, not the outer snap surface, which apparently was not sampled in order to preserve for fingerprinting. No serological testing was done on the area swab for Q1.1 to identify any biological material. Other portions of the sheath were tested for the presence of blood, which was on the back side, down on the bottom. An area identified as Q1.4, swabs of stains on back of the sheath tested presumptively positive for blood and was DNA tested. Mr. Kohberger was excluded from this particular sample, which was identified as a mixture. And trust me, if it was just Kaylee and Maddie's, that'd be known. ISP Lab Report 4. Thus, the government has the burden to prove the when and how of the DNA identified in Q1.1, not your fucking lab expert that's talking about DNA and that it's there. They're not going to come in here and try to prove your case to this jury off of bullshit. It is your job, Ashley Jennings, to prove your case of when and how that fucking sheath got there. Prove it. Prove it. And that is fucking tits. Thus, the government, we're not shifting you guys, the government has the burden to prove the when and how of the DNA identified in Q 1.1. Allowing the use of these two terms would mislead the jury to believe that there was evidence to support the conclusion of direct contact when in fact there is no direct evidence. The admission of these terms would lend to a substantial waste of time in that it would require not only extensive cross-examination of this governmental witness on the topic, but also rebuttal testimony from defense experts on this question. As Lana said above. As Lana said above. I knew that. I was like, when Hitler's going to try to say, can't you just do contact? No. No. This is misleading. This testimony can't come from her, and it's not happening. And if you allow it, this trial is going to take 6 months. Because it would mislead anybody when you have to explain that. So, how could his DNA be there? How could his DNA be there? And you're going to have to go through all of these things. But we're not going to allow you just to say touch. It's trace. If the language is used, the jury might well believe through expert testimony, because they're labeled an expert, as opposed to factual testimony. Now, you guys, think about how much time has gone into this. What we are doing here is, remember that our argument has been like, where the hell, why is the jury, how are these jurors getting it wrong with what reasonable doubt is, or like, what's going on here, right? Well, I had an epiphany last night when I was reading Becca Barlow's and Ann Taylor's and the whole damn team's motion limines, okay? And I had an epiphany. I was like, holy shit. I said, this is what the problem is. I said, these lawyers know how important it is to have their jury not confused, okay? To have this jury not confused. And we need to do it through the motion in limine, because that's what's going to we can't allow our jurors to be confused and then go back there in a room and think that they have their notes that say, well, this Idaho State Police forensic laboratory manager of 18 years said blah, 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 blah. Okay? They shouldn't hear it. They shouldn't hear it. So this is crucial. This part is crucial to make sure that your jurors, that there's a way to say that, oh, well, you know, it's a toss-up with the jury. Well, guess what? There's also ways to help your own case. And it's stuff like this. It's being well versed in doing your research and your homework and seeing, if you know your case and you see your opponent, what they're going to try to do, you want to prevent that. Okay? No, you're not going to try to get the jury to see through this woman, Nollins, okay? And her just to get up there talking about, I've done this for how long, and when we get a sample size that's that big, it's got to be direct. It's got to be direct transfer. That's what she's going to get up there and say. She's going to talk about the size sample. And she's going to say, because of the size sample, that we're not dealing with, you know, we had such a big sample size here It's got to be direct. We don't know what the fuck y'all did with that shit. And that comes up in another one. So the conclusion is that as set forth above, the forensic community has come to a consensus that DNA analysis do not have the expertise to render opinions on how and when a DNA sample arrived on an object. Nobody does. Nobody does. In addition to being misleading and inaccurate, allowing such testimony to result in undue consumption of time. This type of opinion testimony would not satisfy IRE 703 in that the expert can not be qualified to proffer such an opinion because it falls outside the expert's specialized knowledge. The question of how and when is not for a lab analyst, and as the EWG points out, there is no training program in the United States of America that would provide expertise such as an opinion. Because this is why the conclusion is amazing, because she hits all the points. Because if you think that you're going to have her testify based on her experience through training, where was it? On page 1. Yeah, we're not going to say that based on your training and experience that you're labeled an expert, because there is no training and experience for what you're about to try to testify to. So, Mr. Kohberger respectfully requests this court grant his motion limine to exclude any use of language, touch, and contact in the context of the DNA testing of the sheath and any opinion of how and when the DNA on the sheath was deposited. See that? Then they're going to argue and they're going to say that you can use the word trace DNA. That's what is, and so think about this. If you could stipulate to stuff, the state wasn't stipulating to this. The state they couldn't come to an agreement that, hey, we can stipulate to, fine, we'll use direct. The state wants to use touch and contact DNA. They want to be able to use those terms. Otherwise, this would be stipulated to. So there's that. We talked about this yesterday, and this is Dylan. So that was motion limine 7. 8 is, this is so fucking hilarious. So 403B evidence, guys, for the record here. Motion limine 8. As of this date of this filing, the state has only noticed a prior traffic stop as 403B evidence. Mr. Kohberger moves that any other 404B evidence be precluded from the presentation at trial because deadlines for the filing motions in limine are not staggered. So Mr. Kohberger is forced to guess what the state may seek to introduce. So rather than guess, he's just going to go ahead, and this is just how, like, they're on it. We got some smart people. We're just going to exclude all unnoticed 404B evidence. So you didn't, upon the state's timely filing of 404B evidence, Mr. Kohberger will object as appropriate. So the argument in here is that 404B states evidence of a crime, wrong, or other act is not admissible to prove a person's character. So if remember, they're trying to say that they want to introduce the pulling over of Mr. Kohberger when he got his ticket or whatever. And what they're trying to do with that, they can say that it's for identification purposes and it's to show that that vehicle and all that crap. Okay. But technically, if you're trying to show his character with that, the defense could try to keep that out. So permitted uses of other crimes, wrongdoings, or acts is when the evidence is being used for. So if another person is proving motive, opportunity, intent, preparation. So that's what that's about. Character evidence, though. Yeah, no. I'm not going to really spend much time on that. But they're trying to just get ahead, which is no more 403B evidence because you haven't disclosed it yet. Oh, excluding Amazon click activity evidence at trial. For those that don't know what this means, it means that Mr. Kohberger is asking to exclude in order in limine, excluding any Amazon evidence, purchase history, and Amazon click activity evidence by Mr. Kohberger. More specifically, the defendant asserts that with the limited disclosures made by the state, lack of raw data, lack of complete data, lack of explanation of Amazon click activity, or any analysis related thereto, amounts to cherry-picked limited data that does not show a full picture compared to warrants that requested extensive data. The state's refining of all of the Amazon history and Amazon click activity is out of context, incomplete, and unfairly prejudicial, thus making it inadmissible. Incomplete, irrelevant, and unfairly prejudicial evidence is barred by rules 106, 401, 402, 403, 702, and 703 of the Idaho Rules of Evidence and pursuant to the 6th, 8th, and 14th Amendment. This motion should be read in conjunction with motion limine number 2, excluding, remember I told you, Shane Cox, Mr. Cox. And I was like, oh God, what is Mr. Cox going to do here? Any other expert that plans to talk about Amazon clicks? So, introduction. The state disclosed, hey, Mr. Shane Cox is their expert who will testify about Mr. Kohberger's Amazon account and the activity on the account to include logins and Amazon click activity. The state wants to use very specific, narrow dates. The state has not defined, quote unquote, Amazon click activity in any report. Like, what is it? It's not defined in any report or expert disclosures, not provided any opinions or analysis related to the limited data it has produced. The data produced is extremely narrow when compared to the more inclusive and broad warrant and subpoenas. So it's like, why are you only using this? And then they're going to say, well, you can use the rest of the returns. And then Ms. Taylor's going to say, but that's the problem, Your Honor. We don't have the entire discovery of what was produced because we have here, these are the warrants, and it says this is what was produced. And then the state's telling us that they don't have the items. So in our cross-examination, we would need the full data and to compile it to show and have our person or rebut it to be able to show, why didn't you talk, you didn't talk about any of this, or how could this have led up to it? We need the whole picture here. We need all the data so that someone like me could scurry through it and to find, what if there was a click or if there was something that came across your wish list or came across your recommendation list, why would that be? Is there any way to see who was using and we get into this here, it says that there's no way to find out what device did what. Because think about it, if I share an Amazon account with somebody because it's under an email, how do you break up who did what, when, where? The warrant was broad as fuck, so why the data so limited, Heather? Exactly. So Mr. Kohberger faces his capital trial with no more than the state disclosing an expert testifying about dates related to Mr. Kohberger's Amazon account and the production of records and expertise regarding Amazon click activity. Mr. Kohberger is placed in a position of guessing what the state's intentions are. He has consulted an expert. Now, listen, when anybody wants to say that they're not, like they're just trying to, I don't know, you have to give your disclosure, so I don't know what they're trying to do. But here's Ann Taylor. She's like, here's our expert, okay? And his name, Howell, to attempt preparation. And Mr. Howell is he has consulted an expert, David Howell, yes, to attempt preparation. Mr. Kohberger has, and then right here it says, motion limine number 9, exhibit 1 is Mr. Howell's resume. So Mr. Kohberger has learned the limited disclosure leaves him unprepared to confront the evidence. In this ever-evolving age of technology, Amazon uses artificial intelligence, you guys. Yes, they do. To improve the customer experience by helping customers find products that match their interests and preferences. And so this is where it's like, God, it's, you know, if I'm somewhere, you guys, and my phone hears something, I don't even say it. The waitress said it, and then my phone will do something. Okay? We've all experienced if you have a smartphone now. So my question is if your phone, what they want to say, listening to you, and they're using AI in that capacity, depending on who you're around, when you're around them, it just, Victoria's Secret starts sending me, 38 double D bras, because somebody talked about their bra size, that it's always out of stock. Now, does that mean that, I have a fetish with Victoria's Secret bras? I'm just trying to show you guys that, wait, I didn't fucking say that. Why is that being recommended to me? Well, because, I was at Hooters and this girl was talking about her tits and now my phone caught it. I don't know, I'm just making it funny for y'all, but shit like that. So Amazon's use of AI began well before 2022. Important. Often when searching for something on Amazon, the end of the pathway does not tell the beginning of the pathway. And this is because AI is continuously gathering information about the customer's interests and preferences and making suggestions along the way. You guys know how many videos I get suggested to me on YouTube? So this is what interests me about it, is because of what I do. I'll get stuff, I'm like, why did this even come in my feed? Why is this in my feed? Then I realized that back in the day when I had, if you have like your kids' accounts linked up to your shit, then you're getting videos about ABCs and whatever. And I'm like, what is this? And then when it's hooked up to my YouTube, it was like messing with my algorithm. So I had to completely like write them to see how I could do this, so that my channel wouldn't be affected by it, because it was being affected by it. My videos are being recommended to a demographic that I don't want it to be recommended to. You know what I mean? So, yeah, this was just interesting to like think about this. Amazon's recommendation system, powered by AI and ML, significantly influences what users see and clicks on. In 2022, Amazon's AI-driven system did not passively reflect users' searches, but actively guided purchasing behavior based on predictive models. This means that a user's browsing and purchase history may not necessarily reflect deliberate intent, but could have been shaped by Amazon's algorithm. And it's just like YouTube, okay? I had these freaking crazy people who were obsessed with me, tagging me and hashtagging my channel all fucking day, all day long. Talk about just jonesing for it. Well, guess what my fucking shit, like, then it was filling up my algorithm and it was filling up my feed. Like, I don't want to see these idiots. I don't want to see any of their shit. Okay. So there's just all these different crazy ways that your phone also, like when you just go into YouTube and it goes to the next video or something. When I'm scrolling on, I go to Amazon all the time. It's just truly interesting to think that you could use stuff like this based off of supposedly just clicks. It's not even purchases, guys. I mean, we're talking about just clicks. It's pretty interesting. Like, wow. For example, ads that pop up on Facebook and YouTube can be influenced by what you searched for elsewhere. Or I swear to God, if people are searching you. Amazon's advertising system plays a critical role in shaping what users see and click on. Unlike a simple search and buy process, Amazon's AI-driven ad placements, keyword targeting, that's that hashtagging, and personalized recommendations activity guide users towards specific products. Amazon specializes in driving suggestions that are not actively searched for by a purchaser. In this case, the states refining or limiting the Amazon quote-unquote click activity to a specific click or a specific item excludes data, takes things out of context, and could tell a completely inaccurate story to cause the jury, most important part there, to speculate about intent. Full Amazon advertising logs and recommendation data must be reviewed to determine whether a purchase was truly user-initiated or heavily influenced by Amazon's AI. And so what this expert is saying is like, where's the data? Let me look at the data and I'll tell you. Okay. Just like I did with Jennifer Drake's pictures and phone, and Brian Drake's pictures and phone and text messages and shit, like where they were going. You know, I'm coming across all these caliber of guns 6 months before, all the way back to 2016 though. Caliber of guns that killed her husband, and that were found on her phone. And that she is, of course, not being honest with the police that have ever seen those, you know, pictures. But there's also pictures of, let me give another good example of where it could be like, okay, there's a park behind somebody's yard, all right? But inside that park and right at the top of the park, there's also a it's like a cafe. So your location data can either have you in the park playing with your dog, or you could actually be in the cafe drinking at the bar, because it's both going to register. And if you have a dog, then it's, hey, that could have also been what's happening. But now if you go ahead and take pictures and post pictures of, like, I don't know, you eating or drinking, then that's how you'd be like, okay, yeah, then they're not with their dog outside throwing a bone. So it just all comes back down to, like, data. Like, how are you just going to show, like, oh, on this day, so-and-so clicked on this? Like, okay. I'm shocked that there isn't more, that the state isn't doing more. How can the defense even write these things if the state's over here disclosing so organized? Hey, this is the data. Hey, you can have all the data. You know, I struggle with that. So looks weird. For example, suppose someone buys a pair of binoculars on Amazon on a household account with 4 users. Who in the household either searched for binoculars or through some other searches triggered Amazon's AI to a target ad for binoculars? How long were they searching for the binoculars? Were they wish listed for a period of time? Were they placed in the cart and removed? All which could indicate indecisiveness. Did an Amazon AI-generated ad cause the purchase of binoculars as a result of a search for some other product? Were other ads shown to the purchaser by Amazon? How long were the binoculars searched for before being actually purchased? You know, these are all things that you want to look at, what this guy is saying. What types were considered or placed as target ads by Amazon? Were other purchasers made around the same time that provide context? Other purchases made around the same time can provide context to the intent of the purchaser. In our example, the shopper who also purchased a sleeping bag, a tent, a cook stove, long johns, and a safety vest for an upcoming hunting trip. Okay. Thank you guys so much. Let's take a look here in chat, y'all. Moon gifted 5 memberships. Cheers. Larissa, baby. Larissa was the reason that Jax enjoyed his sushi last night there, Larissa. Gifted out 10 green people. Alaska and Dragonfly, 999 Super Sticker. Thank you so much. Super Ninja, 15 months. This is nuts, Anna. I don't even know how people don't see our rights not being allowed. Yeah, I see just a lot of just like how are, either lawyers in other cases aren't doing their job, or we see all this work being done, okay, in these cases, because none of this was ever done for Sheldon Jeter Jr. None of this, like not even like one motion. I mean, nothing was done for that boy. Nothing. Okay, and I watched him get railroaded by the fucking Pennsylvania State Police and the Aliquippa Police Department. I watched evidence miraculously appear in a video, or a blanket, an evidence blanket miraculously appear in a video, and the evidence blanket was never placed in the vehicle ever to begin with, but then it just appears when the car is there sitting at the tow lot. It's like, where did this come from? And this is allegedly when somebody that was a police officer drove the vehicle broke down, and then they eventually swabbed the steering wheel to find gunpowder residue. Get the fuck out of here, you sick fucks. All of that should have been suppressed. All of it. Disgusting. Why wasn't the vehicle towed? Why would you ever put a police officer in a vehicle? And then come to find out, I found more information that this officer just hours before was in another man's, the 911 caller's van to move it. And I'm like, and I have suspicions about this 911 caller in this van. So here he just touched someone's van a couple hours before, moved it at the crime scene, was literally at the crime scene, touched this man van, got in his van, and then he was the one that backed out Sheldon Jeter Jr.'s SUV after just being at the crime scene around like the victim who was shot 6 times in the head, and got into the 911 caller's van, moved it out of the way for no purpose other than to get the van out of the crime scene photo so we couldn't see what van it was. It was so bad. So bad. Not one motion for that boy. 22-year-old black kid. I get fucked. Yeah, you hear me over there. Aliquippa. More importantly, Beaver County. You corrupt as fuck. And your lawyers, they're just part of the system because they're just allowing it to happen because they're not fighting for their clients that they're being paid. Gross. Makes me sick. Same Pennsylvania State Police involved in Bryan Kohberger's case, by the way. Just a different district. So all of this stuff, right? And so here, the defense is saying, we're over here outlining it all to Hitler. Like, we can't even get them to disclose to us their conclusions. What they're going to use here is just one click or whatever it may be. But where's the data of all the time around it? There's Amazon sponsor. They have sponsored production of our products. There's the frequently bought together. The customers also bought this selection, often seem to reflect, organic trends are manipulated by paid placements. I mean, there's just so much to it, and the states make it just seem like, here's this one thing that we're going to use at whatever time period. I have no idea because it's not in their disclosure. Let's keep moving in our thoughts gets due to her being in the forefront of the cycle. Oh no, prayers. Karen, $999. Best. Then I was blown away when I saw this. Shared Amazon accounts also impact click activity, obviously, or search history, obviously. This is another example of incomplete or limited data leading to an improper conclusion in a shared household Amazon account. One person in a household's interest in certain items impacts the entire household account in attributed click activity. This can even happen by the mere existence of proximity to a Wi-Fi network shared by others. Holy shit, you guys. If I was to get on my neighbor's Wi-Fi or my friend's Wi-Fi when I go to their house, think about this. Think about how unreliable this is. See proximity advertising and perceived eavesdropping, it's called. The Amazon click activity in this case is for an account which is a household account shared by Mr. Kohberger and other family members. The click history includes items searched for or viewed on Amazon which might be related to a search conducted by other family members, or might be items suggested by Amazon based on prior interest or prior purchases and AIML making recommendations that look like a click activity. Are you serious? Woo! See when you don't get the whole picture? No wonder why Jay was sitting over there like, I cannot believe that you guys are eliciting this type of material in this case when, hey, you guys got to him by IgG. Awesome. You guys had his DNA on this. Okay, awesome. You got his name. Now what do we got? What do we got? We got nothing. This is the argument for the defense. Let's see if we agree. Mr. Kohberger believes that the state intends to use Amazon evidence to prove elements of its case. I said, holy shit. You know what that means, guys? How do you prove your elements of your case? What's the elements of murder? Premeditated. What? Premeditated. Premeditation. So the defense is saying, holy shit, we believe that y'all are going to try to use Amazon evidence to prove elements of its case. And the only thing I can think of is okay, means, like the means meaning if, okay, he bought the knife. Or, fuck, I don't even think it's going to be that, but premeditation because you bought it beforehand, or you just... I mean, think about it. But elements, what are elements of murder? Elements of the crime. To allow such in the face of the explanation above and the failure to disclose would be unconstitutional and in violation of rules of evidence. Like they can't even literally believe, because this is what they're saying. Mr. Kohberger believes that the state intends to use Amazon evidence to prove elements of its case. To allow such in the face of the explanation above and the failure to disclose would be unconstitutional and in violation of the rules of evidence. What is Rule 106? What does it guard us by? Okay, Rule 106 guards against introduction of incomplete evidence. Boom. In fairness, incomplete Amazon data and quote-unquote click activity should not be offered as evidence. Cherry-picking specific clicks or purchases out of an Amazon click history removes all of the context explained above. And the defense is claiming that this is what the state has done by only disclosing not all the data. We don't have everything. You guys are only focused on a very, very small, narrow dates without context from before, after, nothing. Idaho Rule of Evidence 106 identifies the confines of the completeness of evidence doctrine. And when I was reading this, I'm like, yeah. If a party introduces all or part of a writing or recording statement, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement that in fairness ought to be considered at the same time. That's the key word, and that's the argument. And I learned that the hard way because I objected to it. I said objection, and I'm going to invoke the incompleteness of evidence rule here. Because it's not just, oh, well, if you want to play the entire video, and I said no. These are all a bunch of clips all put together. So not only is it's incomplete, but this is a manipulated, fabricated piece from multiple videos. If they want to disclose each and every video where they got the clip, I want the beforehand, I want the after. You know, you're not just going to take a 3-second clip, get fucked out of 2 hours. It's very similar to what they did with Turtle Boy. Okay. But here, think about this. At least with my videos, I have my videos, right? But guess what they were trying to do then? They were trying to purposely strike down videos so that I wouldn't have them anymore. So then therefore I couldn't go and obtain the whole video that they took clips from because they didn't exist anymore, because they were taken down from YouTube. And so they destroyed evidence after the fact, but after they got their screen grab. I ain't no fucking dummy. But you have to argue it a certain way, because when a judge's oh, well, you can just bring that up in your case. And when you have no, fuck that. No, because there's two things now. A, I can't produce it because it was deleted because they then reported it and got it taken down. But number two is you're changing the whole context. Like, why should I be burdened and the opposing party, it's their, why are you allowing inadmissible evidence is my question. Okay. Because context matters. So, the key word there is at the same time. For like the Richard Allen case for me, to sit here and have jury just literally listen to a clip of whatever the, whatever the supposed 60 some confessions. I want a timeline of when those confessions occurred, what was happening before, after it. But you're not going to just sit here and ramble off 60 confessions that are all put on a tape and just Richard's voice or a piece of paper that was written on some journal. Fuck you. Okay. It's misleading. And it's all these things. Exactly, William. Show the whole video. So, under the common law rule that underpins the Idaho Rule of Evidence 106, the reason for completion doctrine is that there is a danger that an out-of-context statement may create such prejudice that it is impossible to repair by a subsequent presentation of additional material. Exactly. Get fucked. There's no coming back from things, not even from a judge. The rule, thus, Rule 106 requires the admission of those portions of the statement that are, quote unquote, necessary to qualify, explain, or place into context the portion already introduced. Evidence must be relevant to be admissible. The test for the relevancy is set out in 401, which provides that evidence is relevant if A, it has a tendency to make a fact more or less probable than it would be without the evidence. B, the fact is of consequence in determining the action. So it'll be interesting. I mean, all of these cases set precedent too. Whatever this case ruling is on why it would be able to be allowed in or not, it's going to be interesting. Mr. Kohberger intends to offer expert testimony of David Howe at the motion hearing on April 19th, because what, in conclusion, Mr. Kohberger is asking for, so it's not twisted by News Nation, is the court, for the reasons addressed above, Mr. Kohberger respectfully requests this court grant his motion limine to exclude any Amazon and Amazon click activity evidence because it is improperly isolated, out of context, does not take into account advertising influence and omni-channel factors. Mr. Kohberger intends to offer expert testimony. So you're going to hear from this guy at the motion limine, which is scheduled for April 9th. It's kind of like a journal, you guys. Think about that. Amazon is now a journal. Is Amazon a journal? Improper expert opinion testimony. And this is Middleman. This is allowing improper expert testimony violates Mr. Kohberger's federal and state constitutional rights to due process. And I want to show you, is this the one where I just couldn't believe it? Okay. You guys, we just had that huge ass showdown. Middleman was there, but he was not called upon. Ready? This blew my mind. Who is Middleman? Well, on February 17, 2025, the prosecution submitted the disclosure for rebuttal witness David Middleman of Autumn Labs. He runs the whole damn thing. In the disclosure, Middleman offers multiple opinions as to the quality of the work done by Autumn Labs in generating SNP profile and for starting the IgG search for relatives of the SNP profile. In addition to these opinions, Middleman offers multiple objectionable opinions that fall outside of the proper role of an expert and are highly speculative. A. Middleman should be excluded as a witness based on failure to disclose in a timely fashion in due process, as set forth in Middleman's motion limine when they exclude the IgG, which actually, is that next? Yeah. Actually, I'm going to go to this one first, only because I'm going to end with this papow. This blew my mind. Absolutely blew my mind. So I have a question for everybody. Remember how we always heard that they weren't going to use, that the state didn't want to use IgG at all because it was just a tip? IgG. It was just a tip. Well, the state says, hey guys, hey judge, we just need to reference it in a generic way. That's what we were asking to do. We need to just say generically that we got a tip, and that's what led us to get on to Bryan Kohberger. And so we're not going to talk about IgG or anything, but we need to reference this as a generic tip. I said, excuse me? How do you introduce that to the jury? We just got this generic tip that somebody just called in the tip line. Like, that's false. That's totally misrepresentation. Okay? Think about this. So the relevant facts here is Bryan Kohberger is seeking by and through his attorneys of record and pursuant to that moves this honorable court to exclude evidence of IgG testing and searches. To exclude evidence of IgG testing and searches. Now, the state, before we get there, where is it? The state says they filed their motion limine regarding the investigative genetic genealogy, and it says that we are seeking that The court is asking, couldn't believe it, that nobody can, moves this court in limine for an order describing the extent to which the parties can reference and refer to at trial the investigative genetic genealogy used in this case. 2, excluding from the trial any testimony or evidence related to the United States Department of Justice interim policy, the terms of service, or any other genetic genealogy subscription service, the policy debate on whether law enforcement should use IgG in criminal investigations, and any alleged discovery violations. Okay, so I'm like, okay, I saw it coming, right? I saw it coming. The name Bryan Kohberger first appeared on law enforcement's radar in this matter because of IgG. There it is. The state discloses it. This is what they're claiming. Moscow Police Department is saying. Now, I'm not denying that. Okay. Possibly denying it. Who knows? But the time that they said they got it, I fucking question hardcore. So, and IgG has been the subject of many litigation in this case. Most recently, the court found the use of IgG during the investigation did not violate defendant's Fourth Amendment rights. Okay. The remaining question is to the extent to which the parties will be allowed to discuss IgG and related information at trial. So, Judge Hilper said, okay, you not violated, we're not suppressing it, it's not violating, and there's no sanction, nothing. The state's view from the outset has been that the IgG information was nothing more than a tip and was never intended to prove or substantiate defendant's guilt. Motion for a protective order, that's what they said. Instead, the state planned to rely at trial on the evidence developed after the use of IgG, such as the STR DNA analysis that found defendant's DNA matched the DNA collected from the K-bar knife sheath, but it didn't really match like that. You matched to a dad, and dad, But the state also made clear from the beginning that it would need to reference the IgG information in some manner at trial. Well, when did that come out? Because it kind of did, but really important here. The state also made clear from the beginning that it would need to reference the IgG in some information manner at trial. And that's what showed me if they... Remember when people were like, wait a second, so we weren't going to tell Ann Taylor that we ever used IgG. But then at some point, let's say that Bryan Kohberger had a shitty ass attorney and never even opened up the discovery or asked for discovery or did their damn job, right? Then everything would have stayed hush hush like it's been for many cases, right? And then at some point, the state here would have said, hey, we need to talk about how we got to Bryan Kohberger because it wasn't because of a vehicle, right? Okay, so the state's saying, like, we have to somehow be able to talk about how we got to Bryan Kohberger, right? So even if only as a generic tip to help the jury understand how the investigation progressed. Are you insane? I fucking fell out of bed. I said, wait a second. Did they really just put this in writing? They really just wrote that the state also made clear from the beginning that it would need to reference the IgG material in some manner at trial, even if only as a generic tip, just to help the jury understand how the investigation progressed. I cannot wait for this argument. Ashley Jennings takes the podium and says, Your Honor, clearly, everybody had to have known we didn't get to Bryan Kohberger because of that car, those pictures. Come on. Come on. We received this tip and we don't feel like we should have to disclose to the jury because they're going to get confused. But we just want to talk about that, hey, the FBI did work, and based on their work, they were able to get the name Bryan Kohberger. Excuse me? Okay. Huh? Yeah, so we just don't really want to confuse the jury here. So we just want to say how it was, just called in or, well, I guess I have a problem. Why aren't you guys this is what if I would be the judge. Am I confused here, Miss Jennings? I thought that you guys would eventually have gotten to him because of the WSU officers and the way that you put it in your probable cause affidavit that pain came across them, on December 20th. Why aren't they just explaining that to the jury? So this got me thinking about what the hell are they trying to get in front of? Okay, because this is insanity right here. So we just want to be able to reference this though as generic tip. How do you suggest that, Miss Jennings? Well, Bill came up with the idea. And the idea is that we treat it as a confidential informant tip. That we had a confidential informant, and this confidential informant, excuse me? Now we're going to act like there's a person involved? I mean, what are they going to say, you guys? Anyways, the defense, on the other hand, has been all in on presenting the IgG at trial. It has now disclosed two experts, Leah Larkin and Daniel Helwig, whose sole focus is information related to the IgG. The disclosure for Ms. Larkin indicates that the defense wants to discuss more than the IgG itself. Well, guess what the defense just did? Because the defense just toe tagged you guys. The defense is pulling Leah Larkin and Helwig, and they're not going to mention it all. So then how the hell are you guys going to explain how you got to Bryan fucking Kohberger? They just toe tag the state. When Becca Barlow says, well, we're not going to have them testify, and we're not going to be mentioning it. So it's the case in chief of the state. How are you guys going to go ahead and explain how you got to Bryan Kohberger? Go ahead. How about that? Take that. Well, Lana, where'd you come to that conclusion? Oh, because watch. It's funny that, ready? Motion in limine. Bryan Kohberger. He wants to exclude the IgG evidence altogether, son. Well, isn't that interesting? Let's see what we talking about. What you mean here, Miss Kohberger, Miss Taylor, rather? Well, let's see. Well, we would like an order to exclude evidence of IgG testing and searches. This got me all, I was like, damn, okay, relevance. Okay. Let's see what's going on here. A knife sheath that was uncovered at 1122 King Road, Moscow, Idaho on November 13th, 2022. The sheath was tested using standard DNA STR methods by the Idaho State Police Lab. The Moscow Police Department, with the assistance of the Idaho State Forensic Lab, transferred extracted DNA from Q1.1 to Othram's lab located in Texas on November 22nd, 2022. Othram promised to preserve all of its work, in this case, in the engagement agreement, and proceeded to test the Q1.1 DNA using SNP techniques. Othram generated a profile using SNP and began building a family tree for Q1.1, looking for the closest relatives of the sample in commercial databases that allow law enforcement searches, GenMatch, Pro, and Family Tree. On December 10, 2022, Othram was asked to cease work on the case by the prosecutors, despite the fact that genealogy investigation was incomplete. Othram reported that they had identified a number of close relatives to the knife sheath via searches on Family Tree DNA and GenMatch Pro, and suggested obtaining DNA samples from 3 individuals to further their investigation. In the email directing the stop work, lab manager Matthew Gammett directed Othram to preserve the whole genome profile that you have generated on this case and remaining DNA extract. And any data, right? Awesome. After Mr. Kohberger was charged, he swiftly requested discovery relating to the IgG testing and family tree bill that led to his arrest. Mr. Kohberger laid out the rationale for his request in his third motion to compel. The state filed a motion for protective order in advance of Mr. Kohberger's attempt to compel. In the motion for protective order, the state drew a strong distinction between the work done by Othram to generate an SNP profile and the work done to generate a family tree from the SNP data. In effect, arguing that the family tree building did not fall under the Idaho rule of discovery for a number of reasons. However, in this motion and during argument on the motion, the state conceded that the testing done by Othram to generate the SNP fell under ICR. Huge. The state conceded, okay, that it fell under it. As required by Rule 16b-5, the state will produce the report that documents the DNA test. Motion for protective order at 14. The court, after hearing testimony from a number of defense experts, found that the defense had met the threshold, quote unquote, like, that low burden. And so therefore they would have this in-camera review. The defense is asking for sanctions, you guys. Listen up, this is crazy. This is crazy. On November 30th, 2023, the state provided materials to the court for review, along with a table of items. The listed items included FBI materials, ISP emails, Othram emails, and documents, shipment of DNA profile documents, and the contracts. The court ordered release of the majority of the materials with the exception of the generic contract documents of MOU between the ISP, Moscow, Latal, all that shit, right? Awesome. Now, after review of those materials, okay, Mr. Kohberger requested additional discovery materials in his 15th supplemental discovery request related to work done by Othram and the FBI. He sought material encompassing essentially all of the materials that are normally produced, along with lab reports for scientific testing. The state objected, and Mr. Kohberger filed his fifth motion to compel. In a hearing on May 30th, 2024, extensive expert testimony was again heard by the court as to the necessity of the material sought. The requested items included, among other things, raw data files for SNP testing, standard operating procedures, validation summaries, contamination logs, and bioinformation programs protocols. At the end of the testimony, the state, through Mr. Nye, argued the motion to compel. In a striking exchange, Mr. Nye represented to the court as follows. The court makes the decisions, and so we complied with the order. And we reached out to the FBI and Othram and said, you got to give us what you have. We have talked a lot about, we've referenced a letter from the FBI today. I thought the letter itself did a pretty good job laying out what they do and don't have, what they have access to and what they don't. We, in bold, we have talked to Othram. We've spoken to Othram since we have gotten this Exhibit N and provided them these requests. And we are not in the position. For example, requests 1 through 6, he says, we are not fighting those. I'm not saying we are not going to turn those over. In my view, they fall pretty clear under the court's order. The issue is we go to Othram and show them these, and Othram says, we have given you everything. You don't have it, you have everything. Everything we have, you have. That's basically so there's just nothing on this list that we are holding back because we think that we have some justification, like we just don't have it. Now, items 1 through 6 in Exhibit N are the materials described above that pertain to the SNP data testing done by Othram Labs. Mr. Nye emphasized that Othram told the prosecution that as to the specific requests outlined in items 1 through 6 of Exhibit 9, Othram is just telling us we don't have it, so there's nothing we can do. The court then inquired. Court, So Othram has said, you've asked them, and they've said, we've given you everything we have. Mr. Nye, yes. Yes, yes. Ready to fall down? Here it comes. Mr. Nye reiterated that the state knew that if the documents listed in N1 through 6 existed, the state had an obligation to turn those materials over to Ms. Kohberger. And with the rest of it, we are turning it over if it exists and blah, blah. Well, in the court's order related to this specific request in Exhibit N, the court relied in tote on the representations of the state, referring to Mr. Nime's statements about items 1 through 6. The state indicates that the material sought in this request does not exist. Order on defendant's 4th and 5th motions to compel at 8 June 14th, 2024. However, guys, remember we just had that big old hearing? On January 23rd, 2025, a hearing was held before the court regarding the suppression of the DNA/IgG in Mr. Kohberger's Frank's proffer hearing. During that hearing, Matthew Gamet testified regarding the state's relationship with Othram, the contracting process, and specific information about the IgG work done by Othram prior to its SNP data being passed to the FBI. This is why when I was like, when people were like, oh, Anne wasn't on her game. No, Anne couldn't believe what's about to be shown to you guys right here. Mr. Gamet specifically testified that manuals, protocols were provided back to us as part of the bid. Mr. Gamet also testified that contract with Othram specifies that they would keep any data or other things associated with that. And so in this case, I don't know if they have other data or other records that they have kept, they have retained. We have asked them as part of the termination in this case of our work that they would preserve those things, or that they would communicate with both the prosecutor's office and with Moscow Police Department if any of the information was to be disposed or whatnot. You understand this? Anne absolutely fried them. Fried them. And nobody even realizes it yet. Nobody realizes what is about to happen here. Mr. Gamet stated that protocols and procedures were received from Othram in 2021 during the bidding process he believed would, quote unquote, likely exist in response to the new revelations in Mr. Gamet's testimony that the state had in its possession the protocols of the lab through the contracting process as well as other significant materials. Mr. Kohberger filed his 22nd supplemental discovery request on January 28, 2025, and requesting multiple items related to Mr. Gamet's testimony. In its response dated February 11, 2025, the state objected to a number of items. For purposes of this motion, the state response to request numbers 424 and 425 raises the specter of prosecutorial misconduct. Oh my God, I said no way. I don't love you like I don't know. Mr. Kohberger specifically requested all Othram lab protocols, policies, and procedures and validation studies in place in December of 2022 as testified by Matthew Gamet on 1/23/25, as well as all bench notes, electronic data, blah, blah, blah. The state objected to this request in particular as being untimely and stated that, in quotes, the court did not require the state to produce any of the other bidding documents, including Othram's bid submission that discussed Othram's accreditation status, blah, 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 right? This was the first time the defense had been made aware of the contents of the material provided to the court for an in-camera review. Had Mr. Kohberger known that materials contained the information described, certainly would have sought the specific listed information. Because Mr. Kohberger did not know the material provided to the court included references to SOPs and analytical methods, and because Mr. Nime's affirmation represented that Othram has no such documentation, Mr. Kohberger did not ask the court to reconsider its order regarding production of the material. Nor would they have to. Most troubling is the last sentence in the state's February 11, 2025 objection, that while the material provided to the court for review contained references to the SOPs were inadvertently excluded from the material. Now we're getting to some Sallyport shit. Ready? Consequently, the court was misled about the materials reviewed in camera, resulting in deprivation of clearly discoverable documentation. The state objects to the production of materials that it conceded in 2023 Mr. Kohberger was entitled to. Just 6 days later, on February 17, 2025, in its expert witness rebuttal, the state provided disclosure for David Middleman. Middleman is the CEO of Othram Labs. The proposed testimony concerns the testing done by Othram to generate the SMP profile. The proposed testimony covers the testing methods used by Othram, validation, and quality standards. All of these topics were covered in Mr. Kohberger's fifth motion to compel. Ready for this smackage? Under the Due Process Clause of the 14th Amendment, criminal prosecutions must comport with prevailing notions of fundamental fairness. We have long interpreted this standard of fairness to require that criminal defendants be afforded a meaningful opportunity to present a complete defense. To safeguard that right, the court has developed, in quotes, what might loosely be called the area of constitutionally guarded access to evidence. The Idaho Supreme Court recognized that non-disclosure cases can be placed into three different categories. One, the undisclosed evidence demonstrates that the prosecution's case includes perjured testimony and the prosecution knew or should have known of the perjury. Two, a notice of what is specifically desired. Thus, the prosecutor should be well aware of which evidence will be of assistance, and such notice should correspondingly raise the level of prosecutorial duties to disclose. And three, where no specific request for newly discovered and potentially exculpatory evidence was made by the defense. Separately, the problem alleged loss or destruction by the state of allegedly exculpatory evidence. Now, in implementing adequate remedy where justified, usually the only feasible remedy is dismissal of the prosecution or suppression of evidence that would have been impeached by the loss or destroyed evidence. Mr. Kohberger is now asking for the remedy of exclusion because at this late date, he will be unable to investigate the impact of the evidence itself as well as the consequence of withholding such evidence. Even if the missing discovery is produced at this point, Mr. Kohberger's right to receive and review this evidence is guaranteed by the 5th, 6th, and 14th Amendment. In this case, so now this is what happened. In this case, the question of whether the state has withheld or concealed evidence specifically requested by Mr. Kohberger is evident in the record as laid out above. Knowing that Mr. Kohberger was seeking such evidence, the state in bad faith failed to produce the evidence it conceded Mr. Kohberger was entitled to as early as 2023, when Mr. Nine says, yeah, we get it, like you can have that stuff, okay? And now for the first time has informed Mr. Kohberger that this court that some of the material sought was in their possession in 2023. This is insanity because they had this huge suppression hearing, okay? And that's fuck these motherfuckers. Let me just continue on. A, Brady violation. The basic tenet of Brady stands to this day. The suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material, either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. Here, Mr. Kohberger repeatedly requested material related to IgG, and the court found that he had made a showing of materially as to the record sought through discovery requests and motions to compel. The court held 2 hearings on Mr. Kohberger's motion to compel. In its first order dated November 13, 2022, Judge of the Latah County District Court, after hearing evidence, issued an order explaining, that was, I think, supposed to be November of 2024, or 2023, that he met his low threshold, okay? And so the focus of the order was on the second bucket of material identified by Mr. Kohberger, and the state's noting that, according to the state, the rule only requires a disclosure of the results of reports themselves. In this case, the STR DNA profile and the SMP DNA profile created from the K-bar knife sheath. And it is in dispute that the SNP profile itself is the result of a scientific test done on evidence in this case. They were saying, we don't believe that y'all tested, and what you tested came from the fucking knife sheath, you motherfuckers. You understand that? The focus of the order was because Ann Taylor and them were like, listen, this SNP that they've developed didn't come from the knife sheath. Acknowledging that the state had conceded that under Rule 16b-5, it was required to produce the results of the testing done by Othram Labs. The court then conducted an in-camera review. So this was Ann Taylor and team were like, dude, there could be a ton of reasons why, what the fuck's going on, and we need this shit, okay? And so here, it is required to produce the results of the testing done by Othram Labs. The court then conducted an in-camera review. Remember that, when they all had to go meet up, and of the totality of the IgG material provided by the state concerning the construction of the family tree by Othram and then the FBI. The court ordered the production of essentially all of the reviewed material with the exception of certain documents pertaining to the contract between Othram and the state. And that was sealed order for disclosure. Go back and check it out. The state provided test results in the form of 2 large text files. One identified as being the data produced by Othram, and the second as the data produced by the FBI. Still not having received the promised material regarding the SNP testing conducted by Othram, Mr. Kohberger, we're talking about text files. Mr. Kohberger reviewed his request for the material in his 15th supplemental discovery. Renewed. And filed his 5th motion to compel. A hearing was held in the Latah County District Court on May 30th, 2024, during which the state reiterated that Mr. Kohberger was entitled to the requested material, but that requested material did not exist. They're getting caught that it did exist. The requested material was laid out in Exhibit N, and included all bench notes, electronic data, all protocols, SMP, all this shit, all contamination logs, all validation summaries. During the most recent hearing before the court, which we just had, Mr. Gamet testified that during the contracting process, the state had received at least the protocols for the testing from Othram, and the materials most likely were still in the state's possession. Mr. Kohberger renewed his request for the production of this material in light of Mr. Gamet's testimony in its 22nd discovery request. In request number 424, Mr. Kohberger requested all Othram lab protocols / policies and procedures, because guess what? They are missing the work, the data. Remember that came up in the when we're going back and forth with the transcripts? And in place in December. They wanted everything that was in place in December of 2022, as testified by Matthew Gamet on 1/23/25. in which the state responded. Now, this blew me. All firms' protocols and procedures in the context of the bidding process, the documents related to the bidding were included in or referenced in the materials provided to the court to review in camera. The court required the state to discover only the MOU from the bidding documents, see sealed. The state need only discover pages 99 through 103, the memorandum of understanding. The remaining contract documents are not relevant to any issue in the case, end quote. The court did not require the state to produce any of the other bidding documentation, including Authum's bid submission that discussed Authum's accredited status, other customers, past cases, blah, blah, blah. And the SOPs or analytical methods that were to be used through the SOPs were inadvertently excluded from the materials review. These were supposed to be turned over, but they were inadvertently, allegedly, though the SOPs were inadvertently excluded from the materials reviewed in camera. These existed. Remember how they don't exist. We don't exist. So they went to this in-camera review and they didn't bring these and they existed. Okay. The bidding documents referencing the SOPs were included and the court did not require disclosure of the documents or the SOPs. If the defense thought it should have had access to any of the protected materials, the proper procedure, this is what they wrote to the defense. The proper procedure to reconsider its decision on the protective order and blah, 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 right? Vicka Barlow loses her dick. This objection is incomprehensible in the light of the state's concession that the material requested 424 was for materials that the state has repeatedly conceded were discoverable under Rule 16b-5, and assuring the court on May 30th, 2024, that the state understood its obligation to produce the material. Not until February of 2025 did Mr. Kohberger learn that the state had possession of the SOPs and protocols requested in their fifth supplemental motion to compel. Why did the state not alert the court at the hearing on May 30th, 2024, that in part the materials sought by Mr. Kohberger were included in the material provided for the in-camera review in October of 2023? ? And most troubling, why did the state's representation that the materials from Authum did not exist when in fact at least some of the materials requested were in the possession of the Lake Tahoe County Prosecutor's Office? Bill and Ashley, you guys are sick. Sick. Idaho Rules of Professional Conduct 3.3a requires that a lawyer make not a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. In addition, the state seems to imply that Mr. Kohberger had a duty to ask the court to reconsider the decision regarding the material review in camera without knowing that the materials sought were contained in the reviewed materials, something the state now acknowledges and did not disclose. As noted in the state's response, not only was the SOP itself inadvertently not provided for the review, but the inventory supplied to the court and Mr. Kohberger listed the materials in the most generic terms as ISP/Authum contract documents, see Exhibit 3. The state's response appears disingenuous by essentially hiding the existence of the requested material under an insidious and generic title and not informing the court that at least a portion of the documents requested were actually already in the possession of the courts or of the court in the form of in the in-camera submission. The state then falsely claimed that none of the documents requested existed. When you keep lying and lying and lying, this is called the long game. Remember I told you guys in the beginning? When you lie and lie and lie and lie and lie, well, when somebody pays attention to details And you're like, wait a second, that's not what happened on that. Wait a second. No. And that's what Thicka Barlow, welcome, baby girl. The state's objection to the timeliness of the request is not well taken, because Mr. Kohberger only learned for the first time in January 2025 that material sought in his third and fifth motion to compel were actually in the possession of the state after representations that these materials did not exist, and that in fact the Latah County Prosecutor's Office had been in possession of a portion of those materials as early as late 2023. The same argument applies to Mr. Kohberger's request at 425. All from lab materials created, collected, or held pursuant to the policy and protocol in place as testified to Matthew Gamet on 1/23/25. This request includes, but not limited to, all bench notes. They include everything. And request 426 and all blah, 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 including not limited to. Finally, on February 17th, 2025, the state produced a disclosure for rebuttal witness David Middleman of Othram Labs. And this is where they fuck themselves, saying that Middleman will testify about the methods, validations, and quality systems in place at Othram, among other topics. All of these topics are covered by the request for discovery made in the third and fifth motions to compel. If Middleman is allowed to testify, Mr. Kohberger would be unable to effectively confront his testimony given the dearth of documents regarding the lab testing. Counsel for Mr. Kohberger would be ineffective given the timing of these disclosures and the topics raised in the disclosures. As Middleman points out, any credible opinion that Mr. Kohberger might seek would require an expert witness with extensive direct experience with SNP testing and FIG to speak to the highly technical aspects of the testing and FIG analysis. Mr. Kohberger is prejudiced as set forth below. The Due Process Clause of the 14th Amendment requires that the state disclose to criminal defendants favorable evidence that is material either to guilt or punishment. In this case, the court has already found that the IgG materials are material. The state has conceded that the testing from Othram falls under 16b5, requiring that the state produce the material. So that you have to do the two-pronged test to show that it's, so one is material. Prejudice. As set forth above, Mr. Kohberger has requested materials relating to IgG testing in two motions to compel, and in response to both motions, the state has conceded that materials relating to the testing conducted by Othram are discoverable under Rule 16b5. Despite this, Mr. Kohberger sits in an untenable position. Discovery has closed, number one. Expert disclosures have been exchanged, number two. The time for filing motions to dismiss have passed. In limine motions are being filed, and trial is rapidly approaching. Mr. Kohberger's motion to suppress and Frank's are impacted by the failure to timely produce discovery, as these materials may have provided information relevant to the issues presented, particularly what information Othram obtained via the testing. One of the state's arguments regarding the motion to suppress is that the state did not have access to SNP data relevant to medical information. One of the key arguments in Mr. Kohberger's motion, the documents from Othram could have bolstered Mr. Kohberger's arguments, and that's why they kept them the fuck out. Additionally, the state now has noticed witness David Middleman, CEO of Othram, who will testify in rebuttal to Mr. Kohberger's IgG witnesses. The proposed testimony covers topics such as validation, policy, and lab protocols and quality measures. All of these topics were covered in Mr. Kohberger's discovery requests. Mr. Kohberger is left in the position of not being able to cross-examine Middleman effectively due to the complete lack of discovery of the material requested. The prejudice to Mr. Kohberger is clear. Even if the court orders production of the material sought at this late date, Mr. Kohberger is significantly handicapped. Had Mr. Kohberger received these materials in a timely fashion in 2023, he would have been able to utilize the materials for motion work and consultation with experts and been prepared to proceed to trial. Bad faith, number 3. Here, bad faith is evident, and materiality and prejudice should be presumed. The state, after conceding that they were required to turn over the testing, this is the testing! This is what their freaking issue was. They said, we want to see the testing. Failed to do so. When pressed at the May 30th, 2024 hearing on the existence of the material sought, the state firmly stated the material did not exist. Mr. Kohberger has just learned that during that hearing, the state did have at least portions of the requested material, the lab policies and protocols, and SOPs. The state knew in May of 2024 that while they had failed to provide the court with the actual SOP, that the court had substantial material in its possession that would in part have satisfied Mr. Kohberger's request. The state had a duty to inform the court, but instead misled the court into believing that the materials did not exist and were not in the possession of the state. These circumstances have given the state an evidentiary advantage because of their failure to be fully candid with the court during the discovery process. This is especially true in that the state now intends to call a witness from Authorum Labs who can only be effectively cross-examined with the material sought by Mr. Kohberger and concealed by the state. In doing so, the state has hidden or perhaps caused to be destroyed material evidence necessary for Mr. Kohberger to present a full defense. This type of conduct violates both federal and state due process rights. In order to even the playing field, the court should sanction the state, even if the requested discovery is produced. The state has benefited by the taking of testimony of Mr. Kohberger's witnesses at the January 23, 2025 hearing, as well as Mr. Kohberger's timely production of expert disclosures regarding their intended testimony at trial. Given the posture of this case, the conduct of the state in hiding the evidence, and the late disclosures of Middleman as an expert, Mr. Kohberger seeks to exclude all evidence of the IgG work and does not intend to call the witnesses Leah Larkin and Daniel Hegland. Boom! Take that, bitch! We're not calling them! Woo! Now what? This is going to be fireworks on April. We're not calling them. You guys want to get in your generic tip? I got your generic tip. It's these 2 titties. A handful, baby. Unfucking believable. Well, how are you going to explain how you got to Bryan Kohberger? Let's see you go. This is insane. But Ashley Jennings will say something that's ridiculous, but it's fine. So right here, guess what, guys? We're not calling Leah Larkin and Daniel. Number 9, if the court denies this motion to exclude IgG, then Mr. Kohberger may be required to call these witnesses as rebuttal to Middleman. Okay. So it's like, they're not even going to, this is all strategy. So here, furthermore, if Mr. Kohberger does not call Leah Larkin or Hellwood, Middleman's testimony is no longer rebuttal to Take that, you fuck! Woo! Now get up there and testify. And now we're just going to shove it down your fucking throats. So guess what? He's not your rebuttal witness. He's now the state's. And guess what? They never disclosed that he would be, he's never been a witness put on the list for, I want to know if he was an expert ever or just a rebuttal. So let's see. Woo! You guys, take that. Oh my God, you guys understand what that means? That means, here it is. The state has benefited by the taking of testimony of Mr. Kohberger's witnesses at the January 23rd, 2025 hearing, as well as Mr. Kohberger's timely production of expert disclosures regarding their intended testimony at trial. Given the posture of this case, though, and the conduct of the state in hiding the evidence and the late disclosures of Middleman as an expert, Mr. Kohberger seeks to exclude all evidence of the IGG work and does not intend to call the witnesses Leah Larkin and Daniel Hellwig. Furthermore, if Mr. Kohberger does not call Leah Larkin or Hellwig, guess what? Middleman's testimony is no longer rebuttal. It would have to be presented in the state's case in chief. The late disclosure and failure to produce the requested discovery violates not only Idaho law, but also the order of this court regarding discovery and expert disclosure deadlines, as well as Mr. Kohberger's due process and confrontational rights. The court should exclude all references to the IGG process from SNP testing to the construction of the family tree. Oh my God. Now you go back to, sanctionum, baby, sanctionum. I feel like in all cases of murder or homicide, that as soon as there's a homicide case, a lawyer should be assigned with the like a tank team to make sure that shit's being handled right when it does get passed off to the defendant. Because this is fucking crazy. This is absolute craziness. You can ring my bell. This is sick. Like, hey, well, guess what? Let me pull up that, where is this? It should be 2. Oh, yeah, here we go. Let's go back to Middleman here on this. Rylan. Oh, where is Mr. Middleman? Where is he? Oh, here he is. This expert was disclosed as a rebuttal expert relating to IGG matters. This expert is addressed in a separate motion. So Middleman, he was only ever disclosed as a rebuttal witness. Their deadline is passed. Oh, snap! Break, yeah! Okay. Now let's go check out his. I know I have him specifically then. You want to cheat? Well, it's all about a game. Y'all want to cheat and lie? This is 4 people were murdered and they want to fuck around people's lives. I would be so pissed if they were doing this shit and it was my kid that was murdered. I'm pissed that it's not my kid. This is fucking disgusting. Okay, so I think I moved it back right here. I think we'll come back to it. Anyways, so the defense is saying you're going to exclude all the IGG shit, and I don't know how you're going to be able to even talk about the IGG shit. And here's the wait, did I put it all the way in the back like this? Oh, wait, here he is. Oh, here. Okay, here. Now, when you look at the Middleman the improper expert opinion. Now it's like, so that's why I had to say we had to come back to it here. On February 17th, well, first of all, Mr. Bryan Kohberger, by and through his attorneys of record, and hereby move the court for order excluding improperly expert testimony, David Millman, excluding the improperly testimony. There you go. There you go. There you go. And middlemen should be excluded as a witness based on failure to disclose in a timely fashion in due process, as set forth in the Limine with the IGG. Mr. Middleman and his proposed testimony were disclosed for the first time on February 17, 2025. Mr. Kohberger incorporates by reference the facts and arguments presented in that motion that I just read. Due to the later discovery and the motion to exclude IGG altogether, Middleman is no longer a rebuttal witness. And his untimely disclosure puts Mr. Kohberger at a significant evidentiary disadvantage, and his testimony, along with the rest of the IGG evidence, must be excluded. Oh, boy. Oh, boy. All I got to say is, Ashley Jennings, how'd that feel, baby, when you read that shit? You're like, fuck. Fuck, we didn't disclose the discovery. Okay. You want to talk about Bryan Kohberger getting another trial? You want to talk about, this is unbelievable. How is nobody in mainstream media talking about this? How is nobody talking about this, period? Every channel should be going crazy about what, you had a guy that supposedly stabbed 4 students to death, and you need to read these documents and what the hell is going on, and you're just like, wait a second, what did I just read? Middleman offers opinions that must be excluded because they are highly speculative. The state offers the following opinions. This is what Middleman's going to say. Middleman will testify that the collection of DNA evidence from the crime scene, the development of an STR profile, and its entry into CODIS all took place before Othram's involvement in the case. What are you talking about? You can't testify to any of that shit. What are you talking about? You're not involved in anything. You guys, this is hilarious. Middleman offers opinions that must be excluded because they are highly speculative. The state offers the following opinions. With an STR profile already in CODIS, identifying the suspect was ultimately a matter of time. This is what he's going to testify to, is that we would have got to Bryan Kohberger eventually. The FBI just took it over, and they just expedited the process, right? Othram was engaged. Remember the long game? Take the long way home. When you start seeing that people are fucking doing shit that you're doing, you got to play chess, motherfuckers. Ann Taylor had no choice, okay? Because she just toe tagged these motherfucker lying ass bitches. Her and Becca Barlow and Elisa Mathis, Jay, their whole team outsmarted the cheaters. Okay? That's what just happened here. Othram was engaged to build an S&P profile and perform forensic genetic genealogy to accelerate the investigative process. While this approach expedited identification, it did not change the inevitable outcome. The suspect would have been identified regardless. Well, according to everybody else, it was just, you didn't even use IgG. Like, you got the car and, you just would have tracked him down. The FBI's role may have further accelerated the work Othram had already begun, but Othram was on track to reach the same conclusions. This is evident from the preliminary incomplete report Othram provided after being asked to stop its efforts. In this case, additional reference testing would always lead to the identification of Mr. Kohberger, regardless of which agency completed the process or when it occurred. Okay, ready? All of the above opinions are improper because they are highly speculative. An expert opinion that merely suggests possibilities, not probabilities, would only invite conjecture and may be properly excluded. Well, to sit here and say that the FBI would have got to him because it was in CODIS, he was eventually going to get caught, and that's assuming that somebody would. So the first opinion seems to assume that at some point in time, Mr. Kohberger's DNA would be entered into CODIS. The only way into CODIS is via the commission or conviction for felony. This assumption is improper and would mislead the jury and would create cross-examination on this issue that would take an undue consumption of time. But remember, guys, the first thing is that he's no longer a rebuttal witness because Leah Larkin and Howard, they're not testifying. So he was only listed as a rebuttal. So a rebuttal to what? There ain't nothing to rebut anymore, buddy. So who do you got now to testify to anything because you didn't disclose it? So you have nobody to talk about the IgG. So basically, regardless of Hitler and what he could possibly determine, Ann Taylor clipped his nuts and said, no, no, I just love it. So fucking smart. So smart. But it shouldn't be like this. It shouldn't be like this. It should be in the name of truth. It should be in the name of truth. It shouldn't be a game. People's lives. People were murdered. Why are we playing a game? It's wild. This is not a basketball game. I watched Primal Fear last night to remind myself that it's not a basketball game. If Bryan Kohberger is the one, then why does the state keep doing these things to potentially jeopardize putting that man behind bars? What the fuck are you doing? What are you doing? What is up, Deja baby? Not only are the opinions above highly speculative as to what would have occurred rather than what did occur, they are irrelevant. The opinions do nothing to prove guilt or innocence and seemed geared to simply promote the technology of DNA testing. That's exactly what it's doing. While this goal is not improper, the means is. As the disclosure sets forth, Middleman will testify about his lab, their processes, and their quality systems. The speculative opinions add nothing other than confusion and will result in an undue consumption of time. This testimony must be prohibited pursuant to Idaho rules of evidence and Mr. Kohberger's federal and state constitutional rights. So now when you actually then read, okay, what does the state want to do with IgG? Now here's the state who didn't want to tell us shit. If they ever use IgG, that they went this route to find him and all these things. Now the state comes through and says, hey guys, we need, here it is. This is what we need from the IgG. This is our emotional lemony. Okay. Our emotional lemony from the state is, okay, this is what we need. We need for nobody to talk about the DOJ policy and that it was violated. So there's going to be no referencing the DOJ policy, the words terms of service, any of this stuff, and referencing that the FBI did what they did. Okay. The state says, listen, the name Bryan Kohberger, yes, first appeared on law enforcement's radar in this manner because of IgG. And IgG has been the subject of many litigation in this case. Then they say, the state made it clear from the beginning that it would need to reference the IgG information. The IgG information at some point. Where is that? Where is that? I can't wait to that response. The IgG information at some point at trial, even if only as a generic tip to help the jury understand how the investigation progressed rather. What? That's when Ann Taylor, and that's what they've been asking for since the rip. And now you want to fucking say, well, now we have to explain to the jury. And we can't talk about all the fucked up shit we did. So we just need to have you, Your Honor, allow us to just generically somehow make it make sense to the jury on how Bryan Kohberger got on their radar. And then we looked into him. Do you know what a clusterfuck this trial is going to be, you guys? The defense, on the other hand, has been all in on presenting the IgG at trial. It has now disclosed two experts, Leah Larkin and Daniel Helwig, whose sole focus is information related to the IgG. The disclosure from Ms. Larkin indicates that the defense wants to discuss more than the IgG itself, but also present to the jury information one step further removed, including allegations that the FBI use of IgG in the investigation violated a U.S. Department of Justice. Wait, what do you mean the allegation? What do you mean? It ain't an allegation. It's the truth. They admitted to it because they said what databases they used. Are you fucking moron? This isn't an allegation. This is a fact. And God forbid that we want to show, because I was reading this, I'm like, I know why they want to show it. Because they want to talk about the integrity. It's like, here's me. Well, how would you explain a generic tip? Can you explain that? We want to talk about the integrity of the people that did this and have no problem violating their own policies. So what else do they have no problem doing? Switching out, what, samples to be tested? What? Labeling something to, what? The state now seeks an order for this court describing the extent to which the parties will be allowed to reference IgG at the trial. We need an order for you to tell us what we can and cannot talk about when referencing the IgG at trial. Well, guess what Ann Taylor's standpoint is now? No, there is no referencing it. None. None. None's ya. This court should enter an order describing the extent to which the parties can refer at trial to the IgG in this case. The state should be allowed to present the IgG information, at least as a generic tip, to help the jury understand how the investigation progressed. You guys did it in your probable cause. Talk about probable cause. That's how you're going to show the jury how you did it. What are you talking about? You don't need the IgG. You didn't need IgG for probable cause to arrest the man. You don't need to talk about it in court. So what's the problem here? You're going to just talk about the probable cause. This is how you develop probable cause. How are you going to do that? Well, the same way that you did in the probable cause. What do you mean? What'd you do? Well, you led us all to believe that y'all tracked down 20,000 white Honda Elantras and that you guys were just running them all through. And then WSU miraculously came up and found, the vehicle on December 20th or on November 25th or 29th. And then we just relayed that information to Detective Payne, but he didn't get that information until, December 20th. That's what you're going to do. You're going to do the same way that you told all of us that you got to him. That's what you're going to tell the jury. What do you mean? What's the problem? Is it not the truth? Isn't that the truth? Toe tag. Ann Taylor just toe tagged him. Woo, baby. Thank you guys so much for the support and love. Love it. Karen, ring that bell. bill, $398.98 with that bill. Is that right? I will be seeking the truth. Seeking the truth over here. Yeah, and exclusion of IGG is not even enough of a sanction for such serious violations. She should file this to strike the death penalty as well. She did. It's mentioned. It's mentioned in something else where, yeah, to strike the death penalty. You guys, what is their issue? Why do they need to mention that why do they need to mention this as a tip? Evidence must be relevant to be admissible. Evidence is relevant if it has any tendencies to make a fact more or less probable than it would be without the evidence. And the fact is of consequences. You don't get to change, though, just because you have, well, we have his name because we did this. No, what we're going to introduce as a generic tip, the fuck you are. It's going to be out, you guys. You understand that? And then explain this to me. You're going to explain it the same way that you did everything else. You're going to take that probable cause and you're just going to regurgitate it. Okay? Because you want to know what probable cause got you? Probable cause. Do you want to know what the burden is in this case? After you obtain your probable cause, it's called beyond a reasonable doubt. Beyond a reasonable doubt. And all it's going to take is those officers slippy when they're on the stand of when they're testifying to things to then be royally impeached by the defense. Because this, and I hope that they're strong with their arguments. You guys should know your arguments. But what's the problem here? So he's saying that testimony from an investigator as to how an investigation progressed can be relevant and admissible. Who do you think is going to testify to that, though? Payne's going to testify to something that he didn't do? Objection. I'm objecting to that. How are you going to introduce it in the rules of evidence, in the procedure? How are you going to get that in? So in Hall, listen to this. In Hall, a detective testified about how he used DNA to eliminate an individual as a suspect in the investigation. The district court overruled a relevancy objection, and the Idaho Supreme Court affirmed. The court explained, and the testimony was relevant because, in quotes, it provided the jury with a complete story, in that it explained why the police no longer considered the individual a suspect, and, in quotes, provided the jury with details about how the investigation progressed. Well, it progressed because of all the other things that you did. Okay. The court also observed that the testimony, quote unquote, was relevant to refute the defendant's contention that the former suspect was involved in the victim's murder. This is not to say, however, that such testimony is always relevant and admissible. We got to be careful how they argue. An officer testified that a dispatcher had told him that the defendant had said he wanted to kill a cop. The district court overruled an objection on the basis that the statement, quote unquote, was offered for the limited purposes of showing what information the police officers possesses and how this information might bear on the subsequent actions of the officers. The Idaho Supreme Court disagreed, finding that limited purpose was not relevant. Limited purpose was not relevant. The court reasoned that, quote unquote, the facts of consequence during the state's case in chief were facts bearing on the elements of the offense charged and, in quotes, evidence of the motives of the officers' actions on the night in question did not prove any element of the offense charged. But the court noted, quote, the testimony would have been relevant to rebut a defense challenge to the reasonableness of the officer's conduct after hearing the radio report, end quote. Here, the IGG information falls on the Hall side of the line, presenting the fact that law enforcement received a tip directing them toward defendant is necessary to, quote unquote, provide the jury with a complete story. That's funny that you didn't need to provide the finder of fact and the tribunal with a complete story, but we have to make sure the jury has it. by explaining why law enforcement considered defendant a suspect. Why? Why we considered him a suspect? Do you see how interesting now this motion in limine now became? Because if the question's going to be is, how do you think that you're going to introduce this as a generic tip? And this is all that's never going to fly. That's not going to fly. No fucking way is that going to fly. This has turned into a huge problem now for the prosecution, in my opinion, which I'm just some nobody. And unlike the challenge testimony in Bonner, the IGG information is, quote unquote, relevant to rebut a defense challenge to the reasonableness of the officer's conduct. Specifically, the defense has signaled its plan to present to the jury the theory that law enforcement rushed to judgment when it focused on defendant as a suspect. No, I don't think they're going to do that at all. I don't think they're going to do that at all. Rush to judgment. What judgment? There wasn't anything to judge. You guys were getting search warrants back and not even looking at them. There was no, you say rush to judgment. There was not, you guys didn't even judge. There was nothing to judge. Right here, the state is saying, with your memo in support of the motion to suppress, you guys asserting that law enforcement had a different main suspect. You did. A different main suspect prior to the IGG, as well as 2 other unknown male profiles. That is going to be there regardless. Regardless. So you need to say why we focused on the defendant. What? What are you talking about? Like, think about, no. You would still, like, this is not negated. This is still a thing. You had a main suspect. So here's where I'm saying, you guys, just so you know, it's going to come out. Who do you think the main suspect was in this case? There was a main suspect prior to the IGG, as well as 2 other unknown male profiles found in and around the residence. Defendant's supplemental response to request for discovery regarding blah, 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 including on the list of items that weigh in favor of defendant, that 2 other unknown male profiles were found on a handrail and on a glove. But, quote unquote, the police never investigated the leads further. Well, your choices or lack thereof or ignorance or whatever you want to call it, these aren't reasons that you get to come in and do a motion in limine. Okay? This example here, my argument to this would be like, wait a second, we should be penalized because of the way that they conducted their investigation? Are you out of your fucking mind? Like, tell me this is not your argument. Here's me. How would you explain a generic tip to the jury? Let me hear this. Let me hear your proffer on your generic tip. Like, you've lost your mind. So the IGG information is relevant to refute that theory. What theory? It's not a theory. These are facts. It is a fact that there are 2 unknown male DNA profiles. That is a fact. That is not a theory. Fact. Okay? It is a fact that you had a main suspect at one point. It wasn't the name Bryan Kohberger. It is a fact that the unknown male profiles were on handrail and a glove or gloves. Okay? But the police never investigated the leads further. That is a fact. The IGG information is relevant to refute that theory. What theory? It's not a theory. It's just a fact that you had 2 unknown male profiles, blood, and now you have 3 unknown profiles underneath the fingernails of one of the victims. Okay. These are facts. Thus, the state should be permitted to present the IgG information, at least as a generic tip. Like, you guys, come on, Hippler, man. We need this to be able to explain. How are we going to explain this away why we didn't do anything? What are we going to? No, Hippler, this is your argument. This is your argument, Anne. Your argument is so simple. Your Honor, they didn't have my client's name until supposedly December 19th. Your Honor, these victims were murdered from November 13th, on November 13th. What did they do from November 13th until December 19th? We are not going to use a motion in limine, okay, what did they do? What did their investigation consist of between November 13th and December 19th? Thus, the state should be permitted to present the IG. What did y'all do? You didn't get the name until then, so what the fuck did you do? What did you do? What did you do? And you're going to talk about all those roads leading where? Nowhere. To Bryan Kohberger, right? So my question is that you knew you had the blood on the gloves. You knew you had the blood on the railing, right? You were just waiting for that test to come back. Who were you interviewing? What kind of comparison sample DNAs were you trying to get to the lab? Were you working on IgG trees with them? The answer is nothing. You did nothing. And you want a reason to dispute that? No. You need to talk about from November 13th to December 19th what the fuck y'all did. You owe that to the parents. You got parents coming out there, and guess what? Take one out of the damn Karen Reed case, all right? Go and get. I'm sorry, man. Like, Mr. Gonsalves was pissed. Why was he so pissed? And then my question is, how are you going to explain a generic tip so that you can have the jury follow along to your fucking madness? This court should exclude from trial alleged violations of the DOJ policy. I said, have you lost your minds? So you want us to just fluff you a generic tip that's coming from the same damn people that violated a policy which talks about integrity? And the same damn people that y'all work together with and sending emails back and forth with. And no matter how the court rules on the extent to which the parties can discuss at trial the IgG conducted in this case, the court should exclude as irrelevant and prejudicial several categories of information the defense has indicated they plan on raising at trial. Wait, just like you do all the time, you raise questions about the integrity of the investigation, the integrity of the human behind the investigation. Trooper Proctor calling Karen Reed a cunt. Relevant. Why was that deemed relevant? Why did that testimony get to come out? Evidence is relevant if it is probative, having any tendency to make a fact more or less probable, and material being of consequence in determining the action. Whether an issue is relevant requires understanding those theories concerning the crime charged, the elements of that crime. Yeah, you guys know your elements? Because you're going to use Amazon clicks to try to prove one of them. And the ultimate issue that the jury is asked to determine. Even relevant evidence may be excluded by the district court if its probative value is substantially outweighed by a danger of unfair prejudice. So the state is saying that they will be prejudiced if, so the following categories of evidence should be excluded as irrelevant and inadmissible under rule. So here we go. Because they are going to be prejudiced. So the first, this court should exclude testimony or evidence that the FBI's use of IgG in this case violated the DOJ policy, the terms of service of certain genetic genealogy subscription services, or any foreign law. You think that you guys are not subject to character questions? This is an act during your investigation, and you want to present a generic tip from the people that you are trying to then protect based off of the violation of their policy? Make it make sense, man. The math ain't mathin'. Opining the FBI violated the DOJ policy and the terms of service of certain genealogy. We're not gonna. So here you're trying to have Leah Larkin not say this, stating one of the databases isn't. So we're not gonna say this. But remember what she just said. Remember what Ann Taylor just toe tagged them with. Leah Larkin ain't testifying. So Leah Larkin won't be saying any of this, right? None of these allegations, even if true, bear any weight on the issue of defendant's guilt. So sure, okay. Right, that's what they said in Schubert Proctor's thing. It didn't negate the investigation just because he was fucking crazy and said all those things, right? Okay. Tellingly, throughout all the IgG litigation in this case, the defense has failed to articulate any theory by which the alleged violations of the terms of service, DOJ policy, or any foreign law could have any effect whether or not on the reliability of the IgG process. Because that was never their argument, you dumbass. Did you not understand their arguments? Their argument was first that the DNA didn't come off the sheath. Number one. Number two, they were like, what? Where's all the data? Where's all the data so that we can see what the fuck y'all did? And y'all fucking kept it. It doesn't exist. Why is the data doubling? I mean, tellingly. Okay, coach. Stupid. Instead, the defense pieces those alleged violations together to conclude the FBI would not have identified Mr. Kohberger so quickly had they followed protocol. End quote, Leah Larkin. But the speed with which law enforcement identified defendant has no bearing whatever on whether defendant committed the charged crimes. Maybe it would have made you guys fucking, I don't know, investigate. Because you guys, it's supposed to just be a tip like y'all said, but y'all jerked off over it. And then you guys inflamed and made cast viz and phones and cars all going and being, it's got to be done. This evidence is also admissible under Rule 403 of the Idaho Rules of Evidence. This argument becomes null and void because Leah Larkin isn't testifying. So, like, what's your argument? Like, Leah, so you got, okay, so great. Leah Larkin's not going to be testifying. So, scrape that. The presentation of this evidence could unfairly prejudice the state's case if one or more jurors decide to give unrelated evidence less weight because they believe the FBI violated the DOJ policy. No, actually, you're wrong there. Okay, the jury's allowed to give the weight of anybody that testifies. It's their discretion on how they weigh shit, first of all. But if the juror wants to believe that when they pull up the FBI to do the cast shit, all right, and they're the same person that released the name Bryan Kohberger to Moscow Police Department, right? And, well, if I find out that you are the same person that violated the DOJ policy and now you fluffed up your and completely fucked with these data for the cast viz shit and the route with the phone, I mean, everything. Then what? It's like watching the Karen Reed case. All right. Trooper Proctor wrote a report and changed the time from 5:30 to 4:30 to say the car was towed earlier. So, hey, no, we couldn't have planted any evidence because we didn't have the car yet. You know, that type of shit. And made it seem like that the car wasn't towed until 5:30, but really it was towed at 4:30, and lied about it, right? That's that's like the same type of thing. But even, I mean, that's like Karen Reed not being able to point that out. So my argument is the trustworthy of the integrity of the case by same FBI and other roles in the case. And they all overlap. They were all working in concert. Remember, we all did everything together. You're going to use those words to Hitler and say, hey, they said they all did everything together. They all knew everything. The jury needs to hear that. So therefore, one man takes down every man. Okay? Moreover, allowing the defense to present this evidence would turn the criminal trial into something that it is not. What's that? What is it not? There is touch/contact/trace DNA. That's all I see that is linking this man to this case. And you're going to sit here and say making it into something it's not. I think the defense is making it into everything that it needs to be, which is, did y'all plant the fucking sheath, right? Did somebody else plant it and you're covering for them, right? Or what? Are we going to get into the Johnny Cochran and the OJ and you're making it about the police and that we don't want the jury not to find this man guilty because the police fucked up? Isn't that what happens in every case? That's called reasonable doubt. Because of your shady ass shit, I have reasonable doubt because it can't be trusted, right? So you want to try to take the reasonable doubt out of the case is what I'm seeing. What are we trying to make the case, though? That's what I would say. We're going to be turning this trial into something that it's not. What is that? What is it? What are we going to try to turn into? What is it not? What, getting our rights violated? People, you guys just lying? At this court, as this court has observed, violations of the database's user policy may give rise to a civil action. Absolutely, totally. That's a totally different case. I want to talk about your character. I want to talk about your integrity. I want to talk about other shit that you want me to believe that you guys got to Bryan Kohberger because of some fucking database using IgG versus even possibly maybe getting to it earlier, but some other way. I mean, you violated this policy. What's to say you didn't violate a different policy and you actually had Bryan Kohberger's name away? Who knows? But I have the right to know the character of the humans that are running the investigation against Bryan Kohberger, I would think. But when I saw that Ann Taylor and them were arguing over the fact that we don't even know if the sheath is where the DNA came from. Now that to me is interesting because everyone's always saying, you know how hard it is to plant, like, you know, how do we even know that anything was on the sheath? All right. Versus that, well, we got those items. What do you mean? Well, I don't fucking know. You guys aren't turning over your shit, all these questions surround your lab, and you guys aren't where are the protocols? Where's the chain of custody? Where's all this shit? What the hell is going on? This is not normal. So my question would be is what was tested in order to get this sample? And that's what Ann Taylor and them were arguing at the beginning. So I would agree that I agree with the state saying, yeah, we're not going to make this into a civil case. Like, this isn't about a civil case. So I agree with that. Like, we're not talking about that. Second, the court should exclude any evidence or argument on the policy debate of whether law enforcement should use IgG in criminal investigations. Yeah, well, guess what? That's coming from Leah Larkin. So just take that all the way out because Leah Larkin is not. So like when what's his name looks at this and he says, well, they're not using their people, and then they just wiped out your rebuttal person. So it looks like IgG is just completely off the table. And no, you're not going to ever talk about it. So talk about your case however you want, but you're not going to use IgG. Whether as a matter of policy of law, should IgG and criminal, yeah, none of like, so that's all going to be bye-bye. The court has already resolved the privacy issues as they relate to the Fourth Amendment. Any residual privacy concerns fall within the, yeah, I agree. If the defense is allowed to argue privacy policy to the jury, there is a significant risk that a juror will make their decision in the case based on their subjective view on privacy. No, I want the jury to see that you're lying bastards. Okay. That you have no problem if rules are in place breaking them. That's all I care about. So we're going to talk about the fact that if at all, it's going to be talked about at all. Third, this court should exclude any evidence or allegations related to the discovery process in this case. Wow. Have you ever heard of such a thing? You are not allowed to talk about the discovery process in this case. What? See, Leah Larkin, laminating the discovery has been an extremely involved and drawn out process, and opining that the protective order hamstrung the defense. Whether the defense received everything the defense believes it was entitled to during discovery has nothing to do with the defendant's guilt. What? The defendant's guilt? You mean that the defendant's? Are you talking about? Should the right word have been guilt, or that the DNA was on the sheet? You know what I mean? Like, what are you talking about? Or should this have been like a separate motion? I'm totally confused because I thought we were talking about IgG. I thought we were talking about IgG. So here, third, the court should exclude any evidence or allegations related to the discovery process in this case. Using Leah Larkin just mentioning that the discovery has been extremely involved and drawn out process. But whether the defense received everything the defense believes it was entitled to during discovery has nothing to do with defendant's guilt. That's a very crazy sentence, you guys. Remember this sentence moving down the road. And allowing the defense to argue to the jury that the state should have produced more in discovery, that's not what they're going to talk about. This is crazy. You guys, your officers don't even recall what they've done in this case. We're not going to have a problem. Okay? Nobody remembers anything they've done in this case. So, but on direct examination, if I'm Ann Taylor, I don't let the state lead at all. You object to anything that's leading. Okay? These are inexperienced officers. You object. No leading questions, Ann. You hear me? I want no. They are going to work for everything. You hear me, Ann Taylor? Objection leading. I'm telling you, they're going to have to lead Payne. Payne might become a hostile witness because he doesn't remember anything, right? So they're going to have to lead him. And Ann Taylor cannot let that happen. This motherfucker couldn't remember shit. And you're going to use that when they try to elicit answers out of him during this trial that he's just all of a sudden going to remember because he's sticking to a story. Fuck that. You're not sticking to shit. You're sticking to I don't know, motherfucker. You hear me? Tell you, this is going to be a why. I mean, I'm interested to see the patience that Hitler gives in how he presents himself in front of the jury. Where if Ansel wants to object to leading, I mean, hey, sidebar. Or this is a question that was asked. This is outside the scope. Objection outside the scope of this witness's knowledge. This witness does not have personal knowledge of this. This witness says, I don't know to everything during all these other hearings. Now it's within the scope. Get the fuck out of here. No way is it within the scope. They will need to develop a much better strategy for pain on cross-examination. Well, I would just, I'm curious to see how much he's going to be testifying to. Look at this. Suggesting the state has hidden information to which defendant is legally entitled. Well, we would love to be able to handle this before a trial. Okay. The state therefore respectfully submits that the court should enter an order describing the extent to which the parties can discuss IGG at trial and excluding argument or evidence related to the DOJ policy, terms of service, foreign law, policy debates, and privacy, all allegations of alleged discovery violations under rules okay, but guess what they didn't show? Guess what they did not say in here? You know how like Ansel was like here, or Bicabaro said, we're not going to use touch DNA, we're not going to use contact DNA, we're going to use trace DNA. That's the term, trace. Okay? That's what we are looking to exclude, the name contact and touch, and instead trace. So here, when they're suggesting to use this generic tip, why isn't there any suggestion as to how this generic tip what's your suggestion? You notice that? And this is just the state being ever shady and vague and ambiguous. I mean, what? You want to introduce how you got to Bryan Kohberger based off of a generic tip? So you want to lie to the jury? You want to lie to the jury? Like, are you all hearing this? We need some, and they're going to have an argument when they get there of how they're going to suggest it. And the only thing that makes sense in my mind is that they're going to try to say that it was what? A confidential informant? What? I mean, how are you going to say to the jury on how you developed and progressed into wanting to look into Bryan Kohberger into doing these murders? How do you do that? So you want to mislead the jury? You guys, this is absurd. Why can't you just go off of your probable cause affidavit? That's how you led the whole entire nation on how you got to Bryan Kohberger, right? You got probable cause, you got an arrest warrant. Everybody believed you that you tracked down a vehicle that led to Bryan Kohberger and he had bushy eyebrows. And Dylan Mortensen told you that it was a firefighter who had one bush brow, and that, yeah. Lord, protect us all from generic tips. You guys, I have 755 people in here. I'm about to end this live because it's been an amazing live. 4 hours of just, woo, Bryan Kohberger. I told you guys you're going to get it all. Y'all, write in and tell me so that where and what can you say to get this generic tip to let the jury, how are you going to tell the jury on how you got Bryan Kohberger on your radar to then totally disregard all this other evidence between November 13th and December 19th? All of their expert witnesses are full of misleading statements. Why didn't they just get a warrant for Bryan's DNA with their generic tip? Right? Just the tip, baby. Just the generic tip. Give me a t-shirt, y'all. You guys, I mean, thank you guys so much for everybody that's, they're going to have to buy the jury at this point. I love Willie. What is that, my man? Yo, what is this generic tip thing? We're going to, I told you we were going to need to use this down the road. So we just want to treat it as a generic tip. So what would that be? That Bryan Kohberger's neighbor just called in and said, yo, I got a guy down here and he just looks weird as fuck. It's generic. What's a generic tip? Let's Google it. Let's Google. What does Google say a generic tip is? Just the tip, baby. How do you want the world to know? Let's see. Hey, Google. Let's see. Generic tip. Definition. All right. A generic tip refers to a general or standard piece of advice or suggestion, not tailored to a specific situation or context. You guys, 100 got tunnel vision because the FBI didn't give Bryan Kohberger name tip. They were all over this and continue to hand feed. Yeah. What is this? How do you get it? I just want to say a generic tip. I want to put it in motion. A generic tip refers to a general or standard piece of advice or suggestion. So I think this is great. We need just a generic. We just need to be able to. We need the courts to help us out here. How can we get this to happen? Okay. Hey, Bella, what would be a generic way to create a generic tip? How do you generically tip to say that you started investigating Bryan Kohberger? So here, the state also made clear from the beginning that it would need to reference the IG information in some manner at trial, even if only as a generic tip, to help the jury understand how the investigation progressed. That's all, and we want everything else to be excluded.
For someone who just walked in to this conversation, yeah. I need to read what you're asking. Where is it?
Well, when you say the word, when you think of, if I say, hey, somebody just sent in a generic tip, what would you think that would mean?
Someone called in a tip?
Yeah, well, I'm just curious.
Gave a tip?
Yeah, would you say, are they going to try to say that they want to use, act like it was a CI or something?
No, tips, you don't have to give who the tip is.
Oh, so
if you call into a tip line.
An anonymous tip.
You don't have to say where that comes from. Okay,
so do you think that's misleading to the jury if you just say that? So I'm telling you, the state wants to tell the jury that a generic tip is how they started to get their claws in on Kohberger to investigate him.
Okay, I'm telling you that it's not for judicial purposes and what has happened in history. It doesn't matter. We are curious as to how that happens.
No. I'm curious about this motion in limine.
We are curious how we got to Kohberger.
No, here. Read this first.
I'm trying to finish.
Okay. I wanted to be able to ask you.
I did, and I'm trying to answer.
Okay, then go ahead. Why generic, not anonymous? Yeah, just a generic. Maybe that's synonymous for them. Why do they want to keep this new DNA out if it's not BK? They don't. Oh, God bless you. Right at the beginning, it tells you that. No one's trying to keep anything out. They don't want idiots testifying. They want to limit testimony that Jada Miller can't confuse. Generic tip. Use this comment section of this video to let me know what generic tip do you think the state wants to tell the jury on how they started looking into Bryan Kohberger if it's not based off of investigative genealogy, because they want, and so does Ann Taylor. They both now have said hey, we both don't want to ever be able to mention IgG, so you both have it. So, and Now the state's like, wait a second, how are we going to be able to say that we started? And I said, wait a second, why do you have to talk about a tip at all? Why don't you just do what you did in the probable cause affidavit and tell them that WSU officers called you up, just like you had us all believing. All right, guys, we'll see you on the way out, man. Peace out, Girl Scouts. Like it on your way out.